Counsel is present in court. Counsel starting with the Commonwealth. Kindly identify yourselves for the court and the record.
Good morning, Your Honor. Greg Connor for the Commonwealth.
Good morning.
Good morning, Your Honor. Ann Yass for the Commonwealth.
Good morning, Your Honor. Tracy Cusick for the Commonwealth.
Good morning, Your Honor. Good morning, everyone. Kelly Porges on behalf of Mr. Walsh.
Morning, Your Honor. Larry Tipton.
Morning. We need the defendant.
Thank you, gentlemen.
Your Honor, for the record, the defendant's present in the courtroom.
Thank you, Madam Clerk.
Thank you. Thank you.
All right. At the close of yesterday's day, the defense raised with me what I have listed as 5 separate issues that it wanted to alert the court to with regard to the expected testimony of Mr. Walsh today. As an initial matter, does the defense still intend to call Mr. Walsh today?
We do not.
You do not? All right. Does that moot every issue that I researched last night?
I apologize, Judge.
No, I just want to make sure that the 5 issues that you raised and the issue with regard to the plea are no longer on the table. All right.
Good morning, everyone.
Let's colloquy with the defendant then now. And my intention is to defense intend to call any other witnesses.
We are not.
All right, then we'll close tomorrow. We'll do the charge conference immediately after the rest of the day. Let me just put in the record, so the record is complete. The Commonwealth previously, and I ruled on this at the side of the bench previously, the Commonwealth previously asked this court to exclude the defendant's plea of guilty. And I guess the only way that would come in at this point is if he were testifying. But I just want to put in, to the extent that I previously disallowed the defendant to go there with any other witness, and I frankly don't recall if I have previously, I want to put in the reason why I excluded that testimony now. The Commonwealth did file a motion in limine to exclude evidence that the defendant pled guilty to misleading the police into Anna Walsh's disappearance and improper disposal of her body. After consideration, I allowed and still am allowing the Commonwealth's motion for 2 reasons. First, the defendant has failed to show how such evidence is relevant to the remaining charge of murder. And I specifically acknowledge that I read this morning the defense's motion to admit the evidence of his guilty plea, which has been docketed as 216. That was filed on December 11th, 2025, this morning, I believe. I have read it, but it doesn't do anything more than to set forth the elements of crimes of murder. Based on defense counsel's opening statement, it appeared that the defendant was going to testify in this trial. And at that time, he could have made reference to his plea if I so allowed him to. But whether or not he is charged or pled guilty to such actions relating to his prior plea of guilty before this court is irrelevant to whether he murdered his wife. Second, the inclusion of the evidence of the defendant's guilty plea on the 2 charges would risk the introduction of extraneous factors as part of the jury's consideration on the murder charge. As explained by the SJC in Commonwealth versus A Juvenile, 396 Mass 108, 112, it's well established that a jury's verdict must be based solely on the evidence in the case without regard to the possible consequences of their decision. And there's a specific instruction in my draft jury instructions that addresses this. Continuing with this case, the role of the jury is to make findings of fact and determine the guilt or innocence of the accused without regard to probable punishment. To inform jurors of a sentencing consequence of their verdicts is to invite a result possible deviation from the basic issues of the defendant's guilt or innocence.
Joe, he's not taking the stand. No witnesses. Closings tomorrow.
Court
Yes, you're done?
699-701-2007. While the defendant here is not seeking to enter evidence of the possible consequences of a guilty verdict was permitted to tell the jury that he pled guilty to the two lesser charges, there is a risk, substantial risk, that the jurors will consider the defendant's impending punishment on those charges when determining his guilt on the remaining murder charge. Indeed, the defendant has not offered any other rationale for the entrance of such evidence. And as was stated in Commonwealth versus Ferreira, 373 Mass 116, 124, 1977 case, the jury's function is not to weigh possible verdicts with an eye towards dispensing mercy in certain cases or imposing heavier penalties in others. Rather, the jury's function is solely one of fact-finding with respect to the legal standards regarding innocence or guilt. Accordingly, the defendant is not permitted and has not been permitted to put evidence before the jury of his prior guilty pleas in this matter. And Madam Clerk alerted me to also file this morning 321
Welcome,
pause.
Kim.
The Commonwealth supplemental motion to eliminate to exclude evidence of the November 2025 guilty plea, which I will concede I did not read because I just got it when I stepped on the bench, but I'm not sure it makes a difference in light
I
of
think
my
it's
ruling.
moot at this time, Your Honor. Thank you.
All right, is 216 something you filed earlier? Why does it have this number?
No, that's my error, Judge. That's my error. I corrected it on the original. It should be 318. It's my poor vision.
Okay. So just so the record's clear, when I said a moment ago, I did review what the defendant filed this morning. It's just not 216, it's 318. All right. On the docket. All right, I see that I have two other pleadings up here, which I will address in brief. One of them I was going to address anyway. It's in substance, maybe not exactly as it's presented. Those are items number 319 and 320. Let me talk about 319. I haven't read it either. It's a motion to prevent the Commonwealth from basically, I believe, an Attorney Tipton, you can, or Porges, you can illuminate me greater, but you don't want them saying he promised you something in the opening statement that he didn't deliver.
That's right. And after consulting with the Commonwealth this morning, they have no intention, they told us they have no intention of doing that.
So I have already pulled out some case law on this and where the boundaries are, and I was going to give it to you in the charge conference anyway to make sure that you were aware where the boundaries are. The SJC has spoken on this issue of what's permissible and what isn't. The Commonwealth is allowed to get into it a little bit. I will alert you to those cases, and that's where I intend to draw the line as to what's permissible. I probably have them on my bench right now, but I couldn't tell you where they are. But when we get to the charge conference, I'll give those to you so you both have the benefit of my research on that issue. The other motion, 320, is I expect the defense will renew after I bring in the jury, ask you if you're going to present any evidence, and you will rest. And I'll hear you at the side of the bench with regard to that. So now, I do want to conduct a colloquy with the defendant at this point.
Just to be sure he's making a knowing waiver
I
of
hope
the right to
I'm not
testify.
sure I have my.
Joe, after all this, no taking of the stand, no witnesses. The defense going to.
I think the one I need is in my office, so stay tuned. Nobody move.
Why
They
can't they
think
just
we
do
need to
closings
make it
today?
work.
Why do we have to wait?
She doesn't have something on her desk that she needs.
Welcome to Zoom Government.
Well, it's unfair execution
I think so.
that he was allowed an opening to say what the
Please enter the
defense
meeting
was.
code. The meeting has not started.
Oh, yeah.
Please wait or try again later.
And so it's before the jury and he doesn't have to testify about it. And as I said yesterday, and the prosecution will be limited in what it can say about this failure because of the privilege against self-incrimination and the right not to testify. But I am really shocked that this is what they've done. I'm not shocked in the fact that he would have been a disaster on the stand. I mean, on the merits, the decision's correct, but to open it the way they did and get that information in and now say he's not going to testify, so there's no evidence in the record with regard to it, I think is unfair.
Yeah, I don't know if the COE is even on yet. If COE, if there's any way to pull that sound from the opening, oh, there you go. If there's any way to pull the sound from the opening where they indicate that you're going to hear from our defendant, our client, Daddy Short Nuts feeling the way. We got shorted Short Nuts. All right, let's listen in and we'll dissect after the fact.
Madam Clerk.
Thank you, Judge. Mr. Walsh, if you could stand and raise your right hand, please. Do you solemnly swear or affirm the testimony you shall give in the cause now in hearing should be the truth, and that you shall give all true answers to all questions as put to you by the court in the cause now in hearing? So help you God.
I do.
Thank you.
I trust him.
Yeah, excuse me.
You can be seated. I just didn't, was wondering if you were asking me if I wanted him over on the witness stand. I do not. Mr. Walsh, one important decision that all defendants in every criminal trial need to make is whether or not they're going to testify in a particular case. You have an absolute right to testify at this trial, and your right whether or not to testify is solely your decision. This means that you are not required to take your attorney's advice. I'm sure that your attorneys, Attorney Tipton and Attorney Porges, have told you that if you do testify, the Commonwealth has the right to cross-examine you. That is the right to ask you questions. If you do not testify and you and your attorney request me to do so, during my final instructions to the jury in the law on this case tomorrow, I will tell the jury that you, like all persons charged with a crime, have the right not to testify, and that the jurors may not speculate about your decision not to testify. First, I'm going to ask you some preliminary questions. Sir, in the last 24 hours, have you had any alcohol or alcoholic beverages?
No, I have not.
In the last 24 hours, have you taken any prescription medicines?
I have not.
In the last 24 hours, have you consumed any legal or illegal substances?
I have not.
Is your mind clear here today?
It is.
Tell me in your own words, what are we discussing?
Whether I'll testify or not in my trial.
Right? Have you discussed with your attorneys the decision about whether or not to testify in this trial?
I have.
And have you had enough time to discuss your decision with your attorneys?
Yes, I have.
Have your attorneys discussed with you the pros and cons of testifying and not testifying?
Yes, they have.
And do you understand what your attorneys explained to you about your right to testify?
Yes.
Has anyone threatened you or promised you anything to get you to give up your right to testify on your own behalf?
No.
Have you made a decision about whether you wish to testify at this trial?
Yes, I have.
And what is your decision?
I will not testify.
Does any party wish me to ask any further questions before I make my findings?
No, Your Honor.
No, Your Honor.
I find that the defendant, Brian Walsh, freely, voluntarily, knowingly, and intelligently has waived his right to testify at this criminal trial, and that he's done so with the knowledge of its consequences. I accept his decision. We can bring the jury in.
Here comes the jury. Joe, I mean, it's a surprise, but it's sort of not a surprise because we're dealing with a con artist. They indicated, I'm hoping the COE could pull up that sound just so we can listen to it at the tail end here. But what happens to this defense now? Because now he can't get up there and explain what happened.
Well, the jury still heard, that's why it's so unfair to the prosecution. The jury still heard the defense in opening, even though it's not evidence. Now, he won't be able to refer to it in closing because it's not evidence. So it'll be interesting to hear the defense closing here.
What do you mean? None of the sudden death syndrome will come in closing?
Well, he can't talk. Well, he can talk in general about people die and it's unexplained, but he can't relate it to anything Brian Walsh described or said because that's not in evidence.
Yeah. What about this? The defense may not do a closing. Is that possible?
It's possible, but I can't. Well,
Unlikely.
You always do a closing because you've got to try to give the jury some roadmap of what your theory of the crime is. So I expect he'll do a closing. It will be interesting to listen to it. And I'm interested in hearing what the appellate courts in Massachusetts allow the prosecutor to say about his failure to testify after the opening said he would, and the failure of any evidence on, his theory of the crime.
Mm.
I said yesterday when I thought he'd have to testify that this gets messy because the prosecutor doesn't get a free rein to say there's nothing in evidence on any of this.
Yeah, we'll take all your questions after this wraps up, which is fairly quick this morning. I don't get why they just can't do closings. I guess the Commonwealth.
Well, they have to prepare closing, and the Commonwealth is going to have to think. They probably had they probably had alternate closings, but
yeah,
if
Hear all persons have anything to do with the Honorable Diane Fournier, Justice of the Norfolk Superior Court. For your attention, you may be heard. Go to the Commonwealth of Massachusetts in this honorable court. Please be seated. Please turn off your cell phone.
All right, we'll take all your questions after this.
Jurors, we'll start today with the 4 questions. Jurors, were you able to comply with my order that you not speak to anyone about this case?
Yes.
Were you able to comply with my order that you not do any research about the case?
Yes.
Able to comply with my order that you not go on any social media or access any news media?
Yes.
And do you still all have open minds?
Yes.
With those 4 questions all answered in the affirmative, we're ready to begin today's work. Does the defense wish to call any witnesses in this case?
We do not.
Defense rests?
Defense rests.
All right. I'll see counsel at the side of the bench.
So obviously the Judge Diane Fournier, knew that was coming, but with the jury in there,
prepared for it.
Yeah. I mean, at that point, she knew what was coming. So the jurors did not. Now the juror and Brian's looking over at those jurors. You better start looking over, and you're wearing black for funerals, which might be yours metaphorically, Mr. Walsh.
Yeah.
Joe, from a juror perspective, what the hell is he writing down right now? But from a juror perspective, Joe, what do you think this does to the psyche of the juror? They were going to hear from Brian Walsh, and now suddenly they abruptly rest without calling any witnesses, including not calling Brian Walsh.
Well, I think even if they hadn't been told, they came in prepared to hear his story. So I think it's deflating not to get the defense story here. I hope they all remember that the defense lawyer said he was going to testify and tell his story, because now they will be, I think, a little mistrustful of what the defense has said, because this one is a big, big misstatement. And they're not supposed to, you heard the judge, they're not supposed to use it in any way to decide he's guilty. But they've got the absence of evidence. And I hope, this is tough for a jury. I hope they realize that anything that defense said in opening is not evidence.
So jurors, I think I've referred to the trial as, I sort of see it as different chapters of the book. And another chapter of the book is just closed. And that is that all the evidence in the case has now been presented to you. I remind you at this time, jurors, and I reminded you of this at the close of yesterday, the defense has no burden in this case and has no burden to produce any evidence at all. And that's because, as you probably are all very well aware at this point, the burden lies on the Commonwealth to prove its case beyond a reasonable doubt, and it never shifts from the Commonwealth, all right? So what happens next is the next chapter we're going to go to as we move towards your deliberations is that really two things that happens interspersed. I'll explain. And the two things that need left to be done is I need to give you my jury charge, my legal instructions to you. And then you need to hear the closing arguments of counsel, right? So the way that happens is I will give you, when we next reconvene, which is going to be tomorrow morning, and I'll tell you why in a minute. I will give you instructions on the law that's specific to the charge that's primed here. The charge that the crime that is charged here, murder. Then the lawyers will do their closing arguments. And then I come back and give you additional instructions. I call them more generalized instructions. So those two parts of the trial happen: instruction, argument, more instruction. That's going to happen tomorrow morning. And I try to be as transparent as I can in my cases. The reason for that is I don't just pull these instructions out of the ether, as you might imagine. There are instructions and guide instructions, and there I get the input from the lawyers of what they're seeing. And that hasn't happened yet because we've moved at a pretty efficient pace. So I need to do that work with the lawyers today, and I will. And that's what we'll be doing today. What you'll be doing today is getting some rest and some sleep so you can be all rested for tomorrow morning. And I remind you, jurors, I'm going to send you off for the day. I remind you what I just checked in with you. I'm counting on you to be obedient to those rules right to the end, right? Jurors, don't speak to anyone about this case. Don't do any research about this case. Stay off of any social media, news media, and continue to have open minds as we finish these last chapters of this trial. Have a great day.
All rise for court,
I
please.
love the way she explains
Jurors,
what's
close your
going
notebooks.
on to the
Follow
jury.
me.
Yeah.
Most
yeah.
judges don't, and it leaves them, sort of not knowing what's happening. And to the extent she can, she always tells them why they're doing what they're doing. It's really great.
Yeah, look at Brian looking at them like, please save me. And I have a feeling they're none too pleased with
And
him.
you asked how I'd feel as a juror. If I had to come in at
Right.
9 a.m. just to be sent home, I would be not a happy camper.
Yeah, a lot of these people are coming in on the, whether it's the T or drive-in or whatever it is. It's a real pain in the ass to get in there to be turned around. Let's listen to the rest here, and then we'll get some questions.
So I think they're going to now.
Housekeeping things. Yesterday at the side of the bench, we had a discussion
Thank you, JT.
about during Mr. Mu's testimony, in which I asked that a certain document be marked as, I think it was M or N for identification. Madam Clerk, which was it?
N, I believe, with the hammer?
No.
Oh, the other one was N, Your Honor.
And for identification. This is a question to the defense. On cross,
Page 53 of that
I want that
transcript. Your
whole
Honor.
document to be marked for identification. Has that been done?
Okay, I'll get that to the court this morning.
And just so the record is clear, as I understand it, that is a multi-page document of which Mr. Mutlu was asked to review a single page of, but it comprises a record of his police interview. Is that correct?
That's correct, Your Honor.
Thank you, Annalee. Jurors went home because there's no closings, no defense today. So they'll have closings tomorrow.
But they should go over, I think, what the charge, how she's going to instruct the jury. Because there's no reason to wait till tomorrow to
The
do
party's
that.
ready to do the charge conference, recognizing that I haven't given you a draft yet because of the way things played out. I did stay last night and draft the jury instructions with the benefit of two things so far that I considered, or at least three things. One was what I had marked for identification the other day, which is the first 2 pages of the model homicide instructions. I'd asked each of the parties to mark up, so to speak, those 2 pages of the SJC's model instructions. And so you did at my request, and I had the benefit of that information. I also received yesterday, Madam Clerk, if you could get me while I'm talking, the defendant's request for jury instructions concerning consciousness of guilt, emotional evidence, and bad acts. I had that. I considered that as I was drafting the draft instructions yesterday. And I'll talk to you about that. What I didn't do, and I sort of made a mental, because I ran out of steam, frankly, yesterday. I know that very early in the case, before the case started, that the Commonwealth had filed pleadings with regard to jury instructions. And I made a mental note to go back to those this morning, but I didn't frankly have a chance to do that since the day is unfolding a little differently than I expected at the end of yesterday. So I tell that to you so that you know that if there's something that you wrote in there that's still relevant now, it might still be, that I don't have that fresh in my mind anyway. All right?
Yes, Your Honor.
So, said more bluntly, if there's something in there that I don't go over now that you want to persist with, just.
Your Honor, there is actually, with respect to the consciousness of guilt instruction, potentially. I don't know if it would make sense to take a brief break so that I could collect my notes on that topic.
All right. I will take a brief break before we, and what I'm going to intend is this. The draft instructions as I have them right now include what I tried to do is when I was scratching my head, saying to myself, why do they want this instruction in? I put it in anyway, and then I put it in italics so that should be your clue that I'm questioning either why this is in here. For instance, the object of the killing must be a human being that the defense has asked for. Question mark, why are they asking for that? So the italics either means you asked for it, I'm questioning why you want it, be prepared to answer that question. Or in the instance of the instruction, I have instructions drafted right now for, and this is in part 2 of the instructions, impeachment by prior conviction, impeachment by prior inconsistent statement, and impeachment by prior bad act. And in particular, in the prior bad act, I took a swing at attempting to fairly describe the evidence that's been presented to the jury. with regard to the defendant's bad acts. I tried to do it neutrally, but there may be other words that you like better. So those are in italics, even though the whole instruction isn't in italics. Who's closing for the defense?
I am.
And who's closing for the Commonwealth?
So we will never know what happened to Anna Walsh's body.
Yeah.
The address of the Refuse Center, 300 Forest Street, Peabody.
Yes, Your Honor.
The defense now seeking the instruction with regard to the defendant's right not to testify.
Yes, Your Honor.
I'll add it. Commonwealth seeking a mode of instruction.
Yes, Your Honor.
These are standard instructions that are in the, what would be the pattern instructions for Massachusetts.
Yeah. And start putting your questions together, everybody, and we'll send them to Joe once this wraps, which is going to be fairly.
Again, look for the highlighted language in the consciousness of guilt instruction and see if there's some other language you would prefer
You
that
have a pattern,
adequately captures trial evidence.
she has a pattern instruction, and then she would fill in the things that are particular to the facts of this case, and that's what she's talking about. What she has, how she's molded the general instruction.
All right, let me
After
propose
this
this. I'm going to make those edits and additions based on the information that you just provided. And then I'm going to have Madam Clerk shoot you a copy of the draft instructions. And I know you probably want to be spending your afternoons working on the closing arguments. So I think it would be reasonable, given what I think is relative to other cases, the instructions are pretty straightforward. And by that, I mean, there also was a lot of agreement with regard to your submissions as to what you wanted in these instructions. And so it's part of the second half of the instructions that the special instructions. I will go back and look at what the Commonwealth submitted early on in the case. Should I presume that everything you wrote then you're still pursuing today? ADA Cusick.
Yes, Your Honor. The Commonwealth was seeking a direct and circumstantial evidence instruction, a consciousness of guilt from the MCLE instructions, and an expert witness instruction.
All of those instructions are presently in the charge, in the draft charge. So thank you, because that prevents me from trying to find out where it is.
Yes, Your Honor. It's under general instructions at the back of the pleading, the preliminary request for jury instructions, and we just provided the name of the instruction from MCLE.
All right. I don't know if I probably grabbed it. I'm not a huge consumer of the MCLE instructions. I usually use other sources, but you can see what I came up with, and you can tell me whether you disagree with it. But we talked about the consciousness of guilt instruction, and it does not, I've never given, as far as I recall, a version that put my thumb on the weight of the evidence. So it presently either says you've heard evidence suggesting, what page is it on? Hold on, it's on page 27. Yeah, it's some evidence suggesting. I've never, I don't think to my knowledge or recollection, I've never used anything that was stronger than that. Yes, counsel.
I just wanted to say, I hope you haven't spent any time on this. The object of the killing must be a human being. You mentioned that this morning,
It was just not crossed out of your version, I don't believe.
and it should have been.
It's not an issue.
I know. I said
So,
it should have been.
so
Don't
just
wait.
take it, can I take it out?
Yes.
Thank you. I didn't spend any time on that. There are other things I spent, like about 5 issues that were of interest to me, but I learned quite a bit researching those, so didn't have a chance to look at those issues recently, and it's always good to remind yourself of them.
She doesn't seem to
I'll
even
take
have
that
chastised
object of the
you.
killing out.
No. A lot of people are asking if
All
there are
right, so let me get these to you, and I'm going to suggest, what's it, 9:30? Does 11 o'clock sound reasonable?
Yes, Your Honor.
Gives you an hour and a half to stew on. I'm going to get them to you in about 10 minutes. I don't have much to change here from what I drafted. 10:30?
Yes.
Sounds good.
They have to review.
If you need 11, you let me know, but we'll say presumptively 10:30.
Your Honor, could the Commonwealth also request the cases the court referenced about the extent the Commonwealth
I'll
will
get you
mention
those.
opening?
I will get you those. There are parameters. I looked at it about 2 or 3 days ago, maybe over the weekend, something like that. Again, something I hadn't looked at in a while, and it's always good to look at the law, but I'll get it to you.
Thank
I
you.
like them too. I want to read them.
All right, so they're going to take a little break for 57 minutes.
Yeah, they're going to review the instructions that she's got drafted so that they can come back in and either accept them or discuss where it is that they would like the instructions tweaked, so that tomorrow morning at 9, she will have them ready to go and they won't have to start later tomorrow.
Yeah.
So they're going to get that done today.
So let's start there. So Joe, the instructions that she's developing now, it's basically, the way I understand it, it's a template, and then she has discretion and the lawyers can give input for specifics related to this trial.
Yeah.
Like, give us
Yeah.
an example. What
Well,
does
they're
that
not talking about the instruction on murder 1. I mean, that's a standard instruction. You don't change it. You might change a he or she or a they, so that you're particular, but otherwise that's not changing. What they're talking about is the instructions like consciousness of guilt or prior bad acts, those things that aren't necessarily going to be instructed in any particular case because there may not be any evidence about them. She still has a pattern she's starting with. I thought that Massachusetts would have pattern jury instructions that she would begin with, but from what she said, it sounds as though Massachusetts doesn't, because because as I understood it, the prosecution was pointing her to a set of pattern instructions, which they call the NCLE, and she said she doesn't really like those. She goes to a different set of pattern instructions, and pattern instructions are, I drafted these for when we did the federal jury instructions and for Nebraska. Those instructions are standard language for consciousness of guilt. And then since they are not the Massachusetts Supreme Court. If they had been pattern instructions that came from the court, then you don't tweak whether the language is suggest or directs towards, you don't tweak those words. But since they're coming from another source, she's saying to the lawyers, I've highlighted the word you may want to give me other language for. So that's what's going on. It's those instructions. And the one that's really important is the one where she said she has case law that she's not giving to me. I don't know why she isn't thinking of me, because I would like to read them before 10:30, but those are the ones that she's going to give to the prosecution and the defense, and telling them she is going to adhere to what the appellate court in Massachusetts says are the parameters of talking about this. So I don't know whether that means she's got something written that she already gave them or will have something written, but she's also going to give them the case law from which she derived what she's going to tell the jury on the fact that they opened saying he would testify and provided a defense, and now he's not testifying.
Yeah. If you are just joining us, a bit of a bombshell this morning. Brian Walshe has decided not to testify, and the defense has rested its case without calling any witnesses. So no testimony from Brian Walshe whatsoever, no testimony from any other witnesses. And now they're putting together the jury instructions, and the judge has put them on break till 10:30, where they'll come back and hash out some of these instructions and the charging documents, and they will go over that at 10:30. So the judge, Joe, describes this as chapters of a book. You've got the openings, and you've got the Commonwealth case, and then you've got the defense case. So she said, another chapter is closed, meaning the defense case. Again, you have the right in this country against self-incrimination. So he doesn't have to say a word, and the burden is on the Commonwealth. But there's what is the law, and then there's what is the perception of that. So what do you think, if you had to guess, what do you think is going on with these jurors right now? It's 16 jurors, 12 regular, 4 alternates, 9 women, 7 men. What do you think is going through their mind? They had to come all the way into court this morning only to be turned around to go home until tomorrow morning. And by the way, a programming note, and huge thanks to Prof. Joe Explains. Tim Jansen's daughter is getting married this weekend, and the COE and I are heading up there. So we're actually going to be in transit during the day tomorrow, and there likely will be a verdict. I'm going to try to make the day move faster. I don't know how. And if I can join, I will. And if I can't, you'll be in great hands with Joe. But just please understand that that's what's going on. So, Joe, I mean, what do you think is happening to the jurors at this point? They've got to be shaking their heads. They can't talk about it with each other, but what are they thinking?
Well, if I were on the jury, I would still be fixated on, they made me get up early in the morning and drive in from wherever, and I don't know what the weather is like there, only to be told there's no defense case, you can go home. And I would be fighting with myself, saying to myself, don't take it out on the defendant, even though it's his fault that this has happened to me. So that's where I would start. Before I got to anything else, I'd have to get over my peak at what they have done to me this morning. After that, hopefully.
That's the Jersey attitude. I love it.
That's right.
How dare they
Starts with me.
Yes.
That's right. After that, and I hope that they heard what the defense lawyer, what Tipton said in opening, that he said that Brian Walshe will testify. And if so, I think they would be saying to themselves, he said one thing, now they're doing something else. Why would that be? And they're not going to answer that question favorably to the defense, because I don't think there's any way that you could answer it favorably to the defense. And then I hope that they're able to see that the defense that's been raised is not in evidence. And so they shouldn't consider it at all. Although maybe it would be helpful if they considered the ridiculous defense in
Yeah.
terms of finding guilt. So that's where they are. And I think they're probably wondering what happened. And even though the judge said, you're not supposed to consider the fact that he didn't take the stand, he has the right not to take the stand. I'm guessing that they're wondering, why isn't he getting on the stand and telling us what, from his perspective, what happened?
Yeah. What about Dawn 64 here? So is it the understanding that his guilty pleas of disposal of her body and the dismemberment will not be known to the jury? What happens there?
Well, I think they're going to continue with that decision. That was what the prosecutor wanted, that the fact that he pled not be told to the jury. Reason being that the prosecution was worried, and the judge seemed to share the same worry, that if the jury knew that he'd already been convicted, they might be less willing to spend the time going through whether the elements of murder one were met, and more willing to say, well, he's going to go to prison anyway, we can just acquit. Or, somebody, one of them will say, I don't want to be bothered thinking about it. He's going to prison. I'm not voting for guilty. I'm not voting, the jury will hang. And so I don't think they're going to change. There's anything that happened this morning that would change that conclusion. I do not believe, because the defense hasn't asked, that they want to ask the judge to submit murder to or manslaughter to the jury. And if so, the only thing she'll charge on is murder one tomorrow.
What can the defense mention in their closings? Can the defense say something like, along the lines of that, whatever you think, this was certainly not, murder in the first degree.
Yeah, that they can say, sure.
But can they reference manslaughter in any way if it's not listed as a charge?
What do you mean by reference?
Like, can they allude to the fact that it was possibly manslaughter if that's not listed as a lesser charge?
Well, I suppose he can say, there's nothing in the evidence, or there's not sufficient evidence entered by the Commonwealth that he premeditated or planned the murder, or that he had any involvement in the death of Anna Walshe. That he can say without saying, what we contend is Brian Walshe found her dead in bed. That he can't say because there's no evidence in the record. He shouldn't have said it in opening, but he was allowed to say it in opening on the premise that Brian Walshe would then testify and get that information and evidence. That didn't happen. That's why there's the problem with the opening. But he's not going to be able to do it in closing, because now we know that Brian Walshe did not get on the stand and testify. So he will be able to say, the Commonwealth did not prove that Brian Walshe had anything to do with her death. That's fine. He can say the Commonwealth did not prove that this was a premeditated killing. That's fine. I suppose he could say, maybe it happened by, heat of passion, but I don't think he's going to go there, because they're focused on the murder one charge. But whatever he says has to be grounded in what the Commonwealth did, and it has to be focused on the Commonwealth did not prove.
Julia here, could the defense have just done all of this yesterday, basically, and closing arguments could have started to, do you think that they knew this yesterday, Joe, that he was not going to testify? Do you really believe that this decision happened overnight? It seems like this may have been a tactic all along.
Yeah, well, I would say, I hope that this was not a tactical choice at the beginning, because if so, then the defense operated in bad faith and should be sanctioned, in my view. If they went into that opening knowing he wasn't going to testify, and yet opened with, he will testify and here's what he's going to say. So
how do you prove something like, because a lot of people have said Larry Tipton, his reputation has taken a hit here, and that maybe he crossed an ethical line. Is that something that's going to be looked at some point?
There would have to be a complaint filed by somebody. The judge certainly has not indicated that anything on the record that she believes it's true. So I guess I doubt it. It is certainly possible that a defense lawyer will have talked to a client before the trial starts, and the client says, here's the defense I want to make. And the defense lawyer says, okay, I'll open it, but you're going to have to testify. And the client says, I understand that. And the defense lawyer says, it's not a good idea to testify, which clearly they would have said to him at the outset. There's all this bad evidence against you. They're going to be able to hit you with lies all over the place. We don't advise you to testify. We strongly urge you not to testify. And the client says, I will testify and tell this story. So then the defense lawyer can open in good faith, relaying the story that the client is going to. And then the client at the end of the trial says, I've thought this over and I've decided it's not in my best interest to testify. So the defense lawyer on that version has not operated unethically. He may have suspected it was going to happen, but he has a good faith belief based on what his client said that the client is going to testify. Now, could they have done it at, after the state Commonwealth yesterday? Theoretically, yes. But first, I think that would have raised the specter of them knowing a lot sooner, even more strongly. And so if I were a defense lawyer, I wouldn't want to do it right afterwards, because I wouldn't want to encourage the speculation that this was tactical and I knew in advance. Whether I knew in advance or not, I wouldn't want to lend fodder to that fire. And the other thing is, they still need to consult with their client about whether he really plans to testify, and go over with him again the risks that he faces in testifying. And so that's why they took the time and went overnight. Now, also, it could be tactical, because the prosecutor in this situation, one, had to have two closings drafted, because the prosecutor at least had to, on the supposition that after that opening, Brian Walshe would still not get on the stand. And two, the prosecutor would not have had the time to really think about what the closing would be. So now they're going to get another day. The judge said you can have the afternoon and evening to think about your closing. So the prosecutor will have time to think about it. He's got part of it drafted already, or she, I guess it's the other lawyer that's going to do it, has part of it drafted already. I mean, they've got the bones of it drafted, and now they'll be able to go in and fill in, because they don't have to worry about any testimony coming in from the defense side.
Right. Annie K here. Joe, why can't the judge clarify for the jurors the confusion over the defense's opening versus what happened today when she gives her instructions?
Yeah, and she'll do a little. The reason why she can't relates to the privilege against self-incrimination. And I did a video on this with regard to the immunity of Wendy Adelson. But the privilege against self-incrimination there are a number of components to a sentence that is only about 6 words long. You can't be compelled to be a witness against yourself. How many words is that? There are a lot of components to it. There are, Miranda warnings. I can go on that forever. But in this situation, the defendant has a right not to testify, because he has a right not to incriminate himself. And he has a right to the protection in that nobody can say, aha, you're not testifying because you're guilty, because that's drawing an inference from his constitutional right to be silent. So that's where we start. And I assume that part of it everybody can see. But the privilege is considered such an important protection for defendants that right not to testify and have no one comment on it, not the prosecution, not the judge, and have the jury not use it in making a decision. It's so important that it goes beyond the right of the defendant not to testify, and it encompasses the broader picture of the evidence, or what the defense does as its defense. So to say that more simply, it means that it also says you as the prosecutor can't comment on the failure of evidence introduced by the state. It's partly the privilege, but it's also here then the additional element that it's the state that's Commonwealth's burden to prove the case, and it's not up to the defense to do anything. So you can't say to the defense, aha, you didn't put anything in, or tell the jury, did they put in any evidence? Did you hear them make any defense with regard to this? Partly it's the umbrella protection of the privilege. Partly it's the prosecutor's burden, and the fact that the defense didn't do anything is their right not to do anything, because the obligation is to prove beyond a reasonable doubt. So that's where we are. Now what's happened here is the defense opened saying he's going to testify and put in information about the defense that shouldn't be there at all because it is not in evidence. So the instruction that the judge is talking about is, how do you balance those two things? In general, the prosecution would never be able to say, hey, they didn't do anything. They haven't said a word. They haven't told you what happened. Can't do that. But you got to balance that now against the fact that the defense opened providing some information about a defense that's not in evidence. That's the balance. And that instruction is going to lean heavily towards the defendant's right not to testify and the prosecutor having the burden. That's why the circumstance is really, in my view, unfair to the prosecution.
Someone's asking if the defense even had a witness list. They had about 6 or 7 people on there. Obviously, they're not calling them. If you're joining right now, Brian Walsh's defense team has indicated that Brian Walsh is not testifying, contrary to popular belief, and they are not calling any witnesses, and they have rested their case. There was a question, and then we'll play a couple of quick moments from this morning when they made it known that he was not going to testify. But someone was asking, Joe, in this country, if you don't put on a defense, that's obviously a defendant's right. But what's the impact on jurors in terms of sort of a hint of consciousness of guilt? Look, I have no defense. How do jurors perceive this?
Well, jurors always want to hear from the defendant. They always want to hear what the story is. And it is not satisfying to them not to hear the story. The judge can tell them you shouldn't consider that in your deliberations, and they will try. But they're still going in feeling unsatisfied that they didn't get an explanation from the defendant. So that, I think, is always true. Although, again, in this case, they got that explanation from the defense lawyer in opening that they should never have heard. Again, that's why I think it's unfair. But that's where they are. But they're told, and they'll be told again by the judge that you do not consider the fact that the defendant didn't testify. It's up to the Commonwealth to prove the case. It's their burden, and what you have to focus on is, did they meet their burden?
All right, I think this is the part from this morning now where they are indicating to the court that Brian Walsh will not testify, in case you missed it. Here we go.
Walsh, one important decision that all defendants in every criminal trial need to make is whether or not they're going to testify in a particular case. You have an absolute right to testify at this trial, and your right whether or not to testify is solely your decision. This means that you are not required to take your attorney's advice. I'm sure that your attorneys, Attorney Tipton and Attorney Porges, have told you that if you do testify, the Commonwealth has the right to cross-examine you. That is, the right to ask you questions. If you do not testify, and you and your attorney request me to do so, during my final instructions to the jury in the law on this case tomorrow, I will tell the jury that you, like all persons charged with a crime, have the right not to testify, and that the jurors may not speculate about your decision not to testify. First, I'm going to ask you some preliminary questions. Sir, in the last 24 hours, have you had any alcohol or alcoholic beverages?
No, I have not.
In the last 24 hours, have you taken any prescription medicines?
I have not.
In the last 24 hours, have you consumed any legal or illegal substances?
I have not.
Is your mind clear here today?
It is.
Tell me in your own words, what are we discussing,
Whether I'll testify or not in my trial.
right? Have you discussed with your attorneys the decision about whether or not to testify in this trial?
I have.
And have you had enough time to discuss your decision with your attorneys?
Yes, I have.
Have your attorneys discussed with you the pros and cons of testifying and not testifying?
Yes, they have.
And do you understand what your attorneys explained to you about your right to testify?
Yes.
Has anyone threatened you or promised you anything to get you to give up your right to testify on your own behalf?
No.
Have you made a wish to testify at this trial?
Yes, I have.
And what is your decision?
I will not testify.
Does any party wish me to ask any further questions before I make my findings?
No, Your Honor.
No, Your Honor.
I find that the defendant, Brian Walsh, freely, voluntarily, knowingly, and intelligently has waived his right to testify at this criminal trial, and that he's done so with the knowledge of its consequences.
That is it. You just heard him say, I will not testify. Joe Patuto, do you think that this is a true statement here? This is a comment from STS Nation. Defense must be pretty confident the Commonwealth did not prove first degree. Do you think that's why this is happening? Because they feel that they have not proved this, I guess, this premeditation aspect. So they're just going to let the chips fall where they may now without trying to, upend themselves with something that he potentially says on the stand.
Yeah, I guess I would tweak that comment to say, I don't know that they're pretty confident that that's the case, but I believe they're confident that anything they do will make it worse. So that staying silent and hoping that the jury decides that there's not enough evidence on premeditation based on what the Commonwealth did is their best choice, because the other choice would be trying to mount a defense and putting him on the stand. And I think they're very confident that he will step in it and persuade the jury that, yes, he did it. So I don't know that they're very confident that the jury will not convict based on the Commonwealth case, but I think they're very confident that any other choice they made would be worse for him.
You almost said it. Others have accidentally said it. I think we all need some pre-medication because of this, because people are upset we're not going to get to hear him speak. Prof. Joe, putting you right on the spot, not me, Kath428, with the black cat, with the googly eyes. Do you feel the Commonwealth has met the burden of proof here? Do you feel there is the possibility now of a hung jury?
I think the answer to those two questions is yes and yes. I do think they've met the burden of proof, but I think there's always the possibility that you will have a juror who is focused on the trees and forest, and will focus on the particular pieces that the juror says is not enough. I do think there's enough. I think there's overwhelming evidence of what a despicable human being he is and all the things he did afterwards. And I don't think the jury, needs a great deal of particular information showing what he did or what he thought on the front end that would lead to premeditation. So I think it will be to convict. But I think there's always the possibility of a hung jury, and probably the possibility here that one juror will say not enough is higher than maybe you'd see in other cases.
Dom's mom, good to see you often in the chat. This has come up before, but just it's important now. What would happen if he's found not guilty of murder one? since he's admitted to dismembering and getting rid of her body. Again, this is the issue here, is that they basically went with this defense. It was an sudden accidental death. The jurors don't know about the plea, but what happens with this now?
Yeah, two things. One, they will go on if he's found not guilty, which I think that's really a long shot. The judge will then sentence on those two other counts, and then the issue will come up as to whether the Commonwealth wants to make a case, because on the disposal of the body, it's a 10-year maximization to charge with which somebody could get life imprisonment, and that would be murder one clearly. So then if there'd been a conviction, that would be easy. She could sentence up to 20 years. If there's an acquittal, she'll sentence on that, and the Commonwealth will be able, if it chooses, to make a case that this was a disposal of the body in connection with murder one. And the Commonwealth's burden then will not be proof beyond a reasonable doubt, so that there is the possibility that the judge would be prepared to sentence up to 20 years on that charge. Now, the other question, and I confess I don't know Massachusetts law well, I don't know Massachusetts law on this at all. And I've done the greater to lesser before. A, B, C, D is the greater, A, B, C, one of the lessers, A, B, a lesser. Okay. If he had been convicted of murder one, or if he's convicted of murder one, then, excuse me. If he's convicted of murder one, the ABCD, then he can't be prosecuted for murder two. There's only one victim, and we've already got him here. The converse is not necessarily true, or it isn't true, and it depends on the jurisdiction. If you're acquitted of murder one, we do not know whether the jury decided not enough evidence to show that he had any involvement in the murder, or, yeah, there was evidence he was involved in the murder, but we can't get to element D, that he premeditated. Then some jurisdictions will allow the Commonwealth to come back in and charge murder two, because the theory would be the jury did not tell you whether the reason why they acquitted was element D, premeditation, or element C, causing the death, if everybody's following me.
Yeah.
And so some jurisdictions allow you to do it. I think the majority do not, although I haven't quantified it, but I don't know what Massachusetts does.
Yeah. And Joe, I assume the question I'm about to ask, it's going to be a very hard no. But since, with the caveat that the defense said that you will hear from our client, the Commonwealth is still not allowed to indicate in any way that we did not hear. In other words, the Commonwealth can't get up there and say, this defendant's defense said you're going to hear from him, and for some reason we're not hearing. You cannot bring that up in any form or fashion, correct?
Well, the defense could.
No, the Commonwealth.
Oh, the Commonwealth, no. What the extent to which the Commonwealth will be able to refer to any of this is what the jury instruction that the case law says she can give. And I don't know what it is. She hasn't given us the jury instruction, and she hasn't given me the cases, because I would have looked them up as I was sitting here, but I don't know what the cases are she's talking about in Massachusetts. And I suppose I could look them up find them on Westlaw, but then I'd probably lose this stream if I tried to do anything clever like that.
Yeah.
So.
Can they, I guess this is the Commonwealth here. Can the Commonwealth bring up the rolling off the bed in the closing, since that was in the opening?
No, because it's not in evidence.
Okay.
There's nobody during the trial who said what happened was Brian Walshe nudged her and she fell off the bed. And it's not in evidence. It's not anything the jury can consider, and the prosecution can't refer to it.
All right. So this is the other was the moment when Brian Walshe was being questioned by the judge. This is the actual moment. They came on early today, which is also a little strange.
Yeah, and I had trouble getting on, so I missed the first couple of
I
minutes.
think they were up about 10 minutes early on the feed. So This is the moment where I think this is Tipton informing the judge there's no go. We told you he was going to speak, our client, and he's not. Here it is. I agree, Diana.
At the close of yesterday's day, the defense raised with me what I have listed as 5 separate issues that it wanted to alert the court to with regard to the expected testimony of Mr. Walshe today. As an initial matter, does the defense still intend to call Mr. Walshe today?
We do not.
You do not? All right.
Sounds like the COE when she asked if I took the garbage out, and I said no, and she's like, "You didn't?"
Does that moot every issue that I researched last night?
I'll take it back here.
Defense
Here we go.
raised with me what I have listed as 5 separate issues that it wanted to alert the court to with regard to the expected testimony of Mr. Walshe today. As an initial matter, does the defense still intend to call Mr. Walshe today?
We do not.
You do not? All right. Does that moot every issue that I researched last night?
I apologize, sir.
No, I just want to make sure that the 5 issues that you raised and the issue with regard to the plea are no longer on the table. All right. I will conduct a colloquy with the defendant then now, and my intention is to defense intend to call any other witnesses.
We are not.
All right, then we'll close tomorrow. We'll do the charge conference immediately after the rest of.
So I'm going to bring it back one more time. When you hear Tipton arguing in court and crossing witnesses, he is tough and mean as can be and aggressive. Listen to him here.
Mr. Walshe today.
We do not.
You do not?
It's hard to hear.
Yeah, you can hear him because he's.
Right. Does that moot every issue that I researched last night?
I apologize, sir.
No, I just want to make sure that the 5 issues that you raised and the issue with regard to the plea are no longer on the table. All right. I will conduct a colloquy with the defendant then now, and my intention is to defense intend to call any other witnesses.
We are not.
All right, then we'll close tomorrow. We'll do the charge conference immediately after the rest of.
Sounds
So what
like
happened there was evidently the defense had given her 5 issues with regard to his testimony that they wanted her to resolve before they called him. And she said she spent last night researching all of the 5. And then she asked him, are any of them now relevant? And he said no, clearly because Walshe is not testifying. And he apologized to her and she said, that's fine. So that was what that discussion was about, which does tend to suggest that when they left the court yesterday, the defense either planned that Walshe was going to testify or hadn't ruled it out because they gave the judge those 5 issues to consider, which don't matter now that he's not testifying.
Here's a little secret. Men are afraid of women. And right there, Tipton, he was like a little kid caught stealing from a candy store right there. I mean, he was barely audible. You heard her say he's not, like she repeats it. That judge sounded ticked off. I love that phrase. My dad always used to say ticked off. She sounds ticked off and really annoyed. She's got to kind of keep it contained because it's his right to not do this. But didn't she seem a bit perturbed? Is that because she was working on those 5 points, Joe?
She's an experienced judge, and I'm sure that there have been other times when she's done work and it didn't matter. Yeah, she does have that really, I wouldn't call it abrasive because I like her style a lot, but it is a very, it's not a casual conversational. It's not Judge Everett, smiling and, this sort of smooth, friendly atmosphere. It's not that she isn't friendly, but she's much more, task oriented. So maybe she was a little more of that when we heard her just now, she wouldn't say anything, and the appellate record doesn't pick up the judge's voice. All it will do is pick up the words on the page.
Yeah. Thanks again to Mim Benjamin. She's been donating Surviving the Survivor membership. So if you get one, she's a good reason as to why. FYI, since many asked, a non-GPS ankle monitor uses RF. Look at this. Uses RF radio frequency in a home-based station. So PO police officer can only see if they've left the house. Interesting. Thank you to Court Dog Daniel for that explanation.
So that would mean as long as he left the house within the schedule when he had been approved that week, they would know that he wasn't going where the schedule said he should go. What he had to do was meet the time frame, and it wouldn't trigger anything in the surveillance system.
Thursdays in our house. Hey, did you take out the garbage? I didn't yet. You did not?
Well, I would say
not?
that if it's your job, she shouldn't have to ask you. You should just do it.
And I get that you did not. So that very reminiscent of that. My PTSD has fully kicked in. COE, I don't want to push my luck. Any chance we could pull from the actual opening where he says you're going to hear from this client of ours, this Mr. Walshe guy. You're going to hear from him. But Joe Patuto, we're going to hear from Tipton, the male defense attorney. He said that he is the one who's going to conduct closings. But on the Commonwealth side, it's going to be the woman, Lynn Beeland. I don't know if I'm pronouncing that correctly. Sort of the one with the sort of sing-songy approach. But what's the calculus and who does the closings?
They decide that at the outset, who will do opening, who will do closing. And this breakdown where one of the two lawyers does the opening and the other does the closing is not unusual. Writing an opening, writing a closing takes a lot of time because you want to gather the evidence in as persuasive a form as you can. And so dividing the effort is something that a lot of the teams do. Now in the Adelson trials, it was Sarah Dugan who opened, and then the closing was done by Georgia Kappelman. So that's another example of them dividing it up. On the defense side, Tipton did the opening, he's doing the closing. So, what's not allowed usually is to have two lawyers do it. It's not impossible, but usually it's got to be one lawyer, and you pick which one you want.
Lorna McKenzie, who I feel guilt because I've never shouted her out as much as I should have. And yes, I do feel guilt. That's why women can multitask. Yes, I know that for sure. Joe Patuto, let me go to a broader question here. We've got about 15 minutes before they're supposed to come back from break, and then we'll pick it back up, obviously, with court coverage. For those who are just joining, Brian Walshe is not taking the stand, and the defense has rested their case. And thanks to Leah here joining us from the Holy Land, thanking us for our great coverage. We are truly a global phenomenon. But Joe Patuto, here's a guy who we just watched for basically 9 days, shopping around Home Goods, Home Depot, Lowe's, buying 12-pound buckets or bags of baking soda. His wife disappears. He calls people with alibis. Hey, have you seen my wife? There's bloody, human matter and bloody messes in the basement. Are we overthinking this? Is the jury going to get this and say there's no possibility anyone else did this? We never heard about, from an expert about this sudden death. This guy did it. He's a psychopath, guilty, and it's done in 15 minutes. And we ask ourselves, why were we overthinking this? Is that a possibility?
Sure, it's a possibility.
And is it possible that these same jurors, that one or two is completely tripped up on the premeditation? And here's a question about that right there. The judge's instructions about the premeditation will be interesting. I had Josh Ritter on, and I was kind of making a humorous analogy. I've asked, since Bitcoin became a term, I've tried to understand what Bitcoin is. And when you ask, they're like, oh, it's the blockchain. I still have no idea what it is. And I still have no idea what premeditation is, because it seems like it's a very nebulous term in the law.
Well, at the place where it's, at the risk of confusing everybody, the place where it becomes tricky is the line between a premeditated murder and an intentional murder. I mean, premeditated requires a little more than just having the intent to kill. So that's where it gets tricky. But that said, premeditation is, first I have to consider killing somebody. And I say, gee, I'm angry at her. She's having an affair. If it's a divorce, she's going to end up with custody of the kids. And that means I'm going to go to jail because I won't be able to show that I'm the caregiver and I have to be at home. And there are money issues. And if she's dead, I can get the $1 million and the $250,000 from the life insurance policy. And this would be better for me. And we haven't had sex for a year. And there must be other women out there that I'd rather be with, and on and on and on. And what if I do decide to kill her? Can I get caught? How could I manage it so I'm not arrested and nobody knows that I've done it? That's all consideration of the killing. That's stage one. Stage two in premeditation is I decide, I've weighed all the factors and I decide I'm going to do it. And stage three is actually doing it. And so, although premeditation sounds as though you had a week, you had a month or a year, you can do all those every consideration I raised in a minute or two, thinking about, gee, should I, shouldn't I? What are the pluses? What are the minuses? And then you go on to the decision. And as long as it's in that order, you considered it, then you decided, then you did it, it's premeditation. Here, the evidence ahead of time, the asking the questions about what's a good state for a man to get a divorce in? What's divorce law in DC? That sounds like, if the jury wants to draw the inferences, it sounds like I'm considering, what are my options here? Is divorce the best way to go or not? The questions on Christmas Day, or not questions, but the searches that he did. Plane crash in DC, Anna Walsh dead. Sounds as though I'm thinking about her death.
And there's 3 searches, I believe, at least 3 that use the term murder from his perspective.
Right.
I think that could be, no pun intended, his
absolutely,
death knell right
because
there.
that shows that he's not talking about somebody died. He's really focused on murder. But there are other things like that. They all go in this bucket of he's thinking about it. And you can certainly, as a jury, say the jury questions, the thinking about her as dead, the information that he knew about the affair, the information that she was unhappy and stressed out in the marriage, that not having sex for a year, those all can be the things that he's thinking about as to, would I be better off if she was dead? Then he makes the decision, and then he does the killing. And the decision could be the day before New Year's Eve. It could be after the Jem Mutlu leaves, where the decision happens, and then she's killed. So that's what premeditation takes. And that's what the prosecutor in closing has to make a strong case to the jury about. Here's everything that shows that he considered it. Here's the decision. Here's the death. And now look at all the stuff he does afterwards that doesn't make any sense at all, except if you know that he's responsible for the death.
Someone in here just said they're running off to, I think it's TJ Maxx. If you see anyone in latex gloves, call 911 immediately. No one should ever go to a box store without looking for a killer. You should constantly be looking out for that.
They're also in schools and in playgrounds and in, it's not just Home Depots.
Woo. Okay. This is Larry Tipton in the opening. The COE just clipped the first little part of it. I'm not sure if this is going to be within this, but we'll get an idea of what he was at least hinting at in openings. This is defense counsel from opening statements. Shout out to the COE, who is one of the quickest on the trigger, no pun intended. She gets things done fast, quick, and efficiently. I think I told you guys earlier in the week, Carm had an absolute meltdown. Carm carries that cell phone of hers around her neck on it's like a like a
Lanyard.
necklace. Yeah, like a
The
lanyard. And she's constantly bumping into things. So somehow she deleted her, I think it's Wells Fargo account, her app, and she thought all her money disappeared. And the chaos that ensued after that was quite incredible. And while at a girls' basketball practice, the COE fixed the situation and calmed down. But we live in a world of daunting technology. Here is Tipton from the openings.
Brian Walshe lied to the police. Lied to him on January 4th, lied to him on January 5th, lied to him on January 7th. Brian Walshe went to Lowe's and bought tools. Brian Walshe went to Home Depot and bought tools. Brian Walshe, 54 a.m., began a frantic and tragic search that you'll hear about. You'll hear the evidence of that. You will hear evidence that those searches evolved from how best to dispose a body to even darker subject matter. As he wrestled with the fact that Anna Walshe was dead. That evidence that you will hear will be hard to understand, but it is true. On January 1st of 2023,
So we don't quite get there in that clip, but he does say you're going to hear and see the evidence. That's about as close as we get. It is, Joe, it is strange to me. I'm not denigrating criminal defense attorneys. They're important. And a huge shout out to Space and gets done without Space Coast. He fixes the audio, boosts it so we can hear. Yeah, Space Coast, he's sort of a machine back there. So sometimes he gets overlooked. And Space Coast also understands cryptocurrency if anyone wants to ask him about it, but I sure as hell do not. Joe, when he is delivering this, he is so confident, almost condescending, and he is like, but it is true. You're going to hear this, and you're going to think that it's not possible that, he panicked, but it is true. I don't believe that this guy actually believes this, but this is his job. I mean, how do you negotiate that as a criminal defense attorney when this is a very smart man, very well educated? It's his job to defend this defendant, but to say that something is absolutely true when this is my own opinion here. I don't think he believes it is true. It's a weird dynamic that happens in the courtroom. How do you explain that to a law student?
Well, usually, and I guess I didn't listen to the clip carefully enough. The defense lawyer doesn't say it. The defense lawyer simply presents the defense that the defendant has given him, and a defense lawyer would tell you the system says you put the Commonwealth or the state to its proofs. And the state has to prove beyond a reasonable doubt. It's not up to the defendant to do anything. And therefore, then, what I'm doing as a defense lawyer is making sure that the system works properly and that an individual is not found guilty simply because somebody charged him with something, putting the state to its proofs, putting the state to the burden to actually establish the guilt. And the other part of that is, if trials were easy, if you didn't have evidence rules that are very hard to understand, if you didn't have, times when you've got to make a motion or do something or you lose the opportunity to do it, I could go in as a defendant and represent myself with no jeopardy because the trial process is easy. We don't have a trial process like that. You need a lawyer who understands the system to speak for you. When you do that, then you add an element of that lawyer should be able to say on my behalf what I would be able to say in the first place. But the system is so complicated that it's not possible for me to do it on my own. And so that's the other part of the defense lawyer role. It's the defense lawyer is presenting the defendant's case that the defendant, if the system wasn't complicated, could do on his own. And so as long as the defense lawyer is not presenting a defense that he knows to be a lie, or puts on a defendant who is going to perjure himself, the defense lawyer's on of the process and would say to himself, I'm doing what the system requires. I'm speaking for this individual, and I'm putting the state to its proofs.
Do you think, and I'm going to get to Alicia's question here in a second, do you think there was a scenario last night where Tipton gave it some thought and maybe went to the jail and said, "You got to rethink this. This is a really, really bad idea, because whatever you say, they're going to just jump on you. They're going to cross-examine you. Really, you got to think about this." Do you think?
Yeah, sure. That's his job.
Is it possible, from Alicia Elliott here, that the state did not pursue other possible avenues of questioning because the defense stated that Brian Walshe was going to testify? How does this affect the state's case? Good question. I mean, did they not ask stuff under the assumption that they were going to hear from him?
That's a great question.
Yeah.
And it may answer the question that I kept having as to why the prosecutor was doing things that the defendant had conceded. But that's a great question, because it may explain why the Commonwealth seemed to do more and go down more roads than seem necessary given the defense. So to put it, they did do more than simply focus on his claim that he found her dead. I mean, they put in more evidence that they needed if that was the only issue. Really good explanation for why they did more.
I just had a weird thought. You guys know I'm a little weird, because someone here says TJ Maxx has the best snacks. I'm tempted. What if I went to Home Depot today, just a full-on Tyvek suit with a hood, a mask, latex gloves, booties, and I just started pushing a shopping cart? You think I would be stopped, Joe Patuto? You think anyone would ask me a question?
Why don't you go try it, and then you can report?
It would actually be
interesting empirical research here.
COE, if we have nothing to do today on top of the 4,000 things, let's do that, man. Let's dress up in a full-on Tyvek suit. I'll wear a surgical mask, goggles, booties, latex gloves, and I will pick up baking soda, cement, duct tape, hacksaws, whatever. Let's see what happens. Let's film it. I want to do this. Yeah, I want to do this. And then, by the way, I can go to Home Goods right after, because someone said,
I'll tell you, I think what would happen to you at Home Depot is everybody in the store would give you a wide area to operate in.
I would finally, I'll go up to customer service. I'll have like an oxygen mask on. I'm just curious to see what people will do.
It would be great research. Take a camera and you can do a show on it.
COE, let's do it. Let's do it, please. Tipton said it'd be hard to believe, and it's true. That was his verbiage.
Okay.
And then Kim Stang-Toon said, is it true that it's hard to believe? But he said he did use the word, and it's true. So that's interesting.
It's probably beyond what he should have said, because he shouldn't be commenting on his belief in the evidence, really. But, it was a little thing in the opening, and he may have misspoke. And the person who did that could be right that he's saying it's true that would be hard to believe.
Cheryl, you are not nearly as paranoid as you need to be. I just think that you'd be doing a bit of spray painting. Not when I have a decided it would be too time consuming to wait to put all that stuff on after you got home and started the job. I might have a snorkel in my mouth to breathe. So, going through the mask. I really want to do this now, COE, and we have a Home Depot literally a mile from our house. So, why is there a court recess now? Joe, the judge is trying to put together some documentation for the judges, and they're actually supposed to come back at 10:30, which is right now.
Yeah, they're looking at what the judge drafted, and they will come back. It's what would be called a instruction conference. They will come back and say, you said this here, we would prefer this, or we prefer you didn't say this at all. So, but they needed time to at least read what she had in order to make the comments. So that's what they're doing now.
Joe, I couldn't be arrested for that, right? I have the freedom to walk around.
No, what
Home Depot.
is there a crime out there that says you can't wear a snorkel and goggles and whatever
I
else
don't
you were
know.
going to do and walk in a store?
Maybe I don't know. Maybe it's like screaming fire in a movie theater that I'm creating. I'm stirring up panic or something.
Well, that you've got at least you couldn't get convicted of it. If the question is, could somebody come in and ask you some questions? Sure. Might you be escorted out of the store? It's not impossible. Could they arrest you? There's no probable cause of any crime there that I know of.
Let me talk to Tim Jansen at the wedding and see if he'll defend me if I go ahead and do it. I wonder if the big question is, would the COE follow me? Space Coast would do it. The COE should just look at me.
I think it would make a great program.
It would be interesting. Let's put it that way. So here we are, 10:30, and I'm now talking about walking around Home Depot with a snorkel and a full-on Tyvek suit. So that's, you know, who would love it? My kids would absolutely love. My daughters would be so embarrassed. Yeah,
The
look at
older
this.
one, I'll bet.
Now Space Coast is thinking it would make for great shorts, TikToks. Let's do it. Let's do it. Spacey, fly out here. Let's do this. By the way, there's a 49% chance that my kids survive the weekend. Grandma Carm is going to come over and babysit. I've given her instruction. The only time Carm ever got in a car accident in her life was with me when I was about 11 years old. She's got a clean record since then. It was completely her fault back then, but I've given her instructions. She's babysitting the kids. This is all like a last minute thing. And I don't know if she got offended, but the COE and I were like, don't drive the kids around. Let them just hang out. Joel, you live in Florida. I'm sure it is normal where you are. Carm would just look the other way and think I should make Carm do it. Get Carm dressed up. Then she won't, older woman. They won't harass her as much. But
you want to be harassed. You want to make a good show.
Yeah,
unless
I know.
something occurs.
That's true. That's true. So Joe, after we get through with this part with the judge, what do you think both sides do? They go back to their offices, and are they reading these aloud? Are they practicing these closings in front of each other? I know you're not necessarily a practicing attorney, but you teach attorneys. What do you think the process is here the rest of the day for them?
Yeah, they've got part of it written already, and they will sort of finish up what they want to say. And what I did and what I advised students to do when they went and practice is to, run it by, practice it out loud, but to do it in front of not other attorneys in the office, but to do it in front of people who are not lawyers, because that's who the jury is. And then see what seems to work with your audience of non-lawyers, where they have a question, and then you would tweak it. But yeah, you want to run it. You want to be persuasive. You want the words to be persuasive. You want the presentation to be persuasive.
Yeah, I'm looking at some of the comments here. Where did this one just go? Someone said, right here from Cheryl, being a cheater is not a death sentence. Meaning Anna should not have been murdered for this. But I'm just wondering, on the flip side here, again, Joe, it only takes one person to sort of upend this whole jury. I mean, there's no way. I mean, I don't think there's any way, and tell me if you think differently, that there's going to be an acquittal where they're.
Yeah, I agree with you.
Yeah, I don't think all 12 are coming back, but I can see one or two saying, I just don't see the premeditation. I see this guy literally I feel like he just snapped, and therefore I can't vote in good faith for murder one. And then there's nothing else to go to. And that's where I think that's the most vulnerable potential here for a mistrial.
Yeah. And if that happens, the prosecutor has the complete right to retry on murder one, or to charge murder two, or to allow him to plead to murder two. So if it's a mistrial, it's time and effort and money and the witnesses coming in. It's not a negligible thing, but it doesn't mean he can't be convicted of murder.
Yeah, this is a great question here, or comment. I believe he strangled Anna, which is premeditated because it takes a minute at least to strangle someone, especially if they fight back. Hence, the broken necklace. Therein lies a great question. Is strangulation, Joe, in and of itself, considered premeditation? Because that could
No, because if I told you there are three parts, you have to consider it and then decide to do it and to do it. Strangulation certainly shows intent. It may show the deliberate nature of it, but it doesn't in itself show that you considered it before you did it. Right?
COE, no, because of I guess the time factor. We got to this question already. COE. Hate to do this to everyone. It is getting to be unbearably cold here, dipping into the 70s. In Canada, they had snow and crazy wind. Let us know, mainly because I'm a sadist, what it's like for, or a masochist, what it's like for you guys where you're living. That's where we're up to the weather portion of the show now. Let me know what the weather is like in your neck of the woods. Also, selfishly, I've got to take my kid to the World Cup. The World Cup is every 4 years, and it's in America this year. My kid is obsessed with soccer. Anyone have any thoughts on how I can get tickets for under $10,000 a ticket, so I don't have to be in debt for the next 30 years to take my kid to see the World Cup? If anyone has a brilliant idea, please email me, survivingthesurvivor@gmail.com. Someone just said it is, look at this, 12 degrees. Don't know where that is. Is this true, Joe? Snow in New Jersey?
I haven't been out, and I don't know.
Minus 15 Celsius. Look at this. Are you really from the Northeast, Joel? Yeah, your blood thins very quickly. By the way, I have a friend in Washington State. They've got, I think, the worst flooding in the history of their state. So, and I saw someone in the chat earlier. If you're in Washington, be careful and watch out, because it is deadly flooding going out there. 70 degrees in the Mojave Desert. That seems pretty cool. 9 degrees Celsius in New Delhi. Welcome to New Delhi. We are truly a global phenomenon. What does this mean? The World Cup might change locations? What do you mean about that?
Huh.
What's going on there? What are we talking about? 50 in Denver, 21 in Rochester, 12 in Minnesota. Minnesota seems like have you been to Minnesota? I was in Minneapolis once. It's absolutely beautiful, but how do you live in a place where it's that cold, like 8 months a year?
And they have these gizmos where if you're going to park your car outside, you plug it in so that you keep the engine or that area of the car heated so that it doesn't freeze and you can drive the next day.
-9 in Montreal. It is dark in Sweden. Yeah, they have like 7 hours of sunlight. I would kind of like that in a weird, twisted way. I function better when it's dark, so I might have to move further north. -14 in Gatineau, Quebecois. Space Coast, is that right? I don't know. The World Cup may not be here. Are you really? They're talking because of the ice issues. Joe Patuto, what else do we need to know as we wait here for this judge to come back? They're now running about 10 minutes late. They said between 10:30 and 11. It is now 6 Celsius in Lower Austria. But Joe, I mean, what are they gonna sort of negotiate the points when they come back right now, or is this just going to be here's what it is, and take it with you, or will there be
No,
some sort of
they have a chance. You heard the judge say she's italicized some things where she wants to hear their views, and they can come in and say, with the areas that are not italicized, that one side or the other wants something different. It may be that the lawyers will agree, and if so, the judge will probably do it. Other times, the defense may want something, and the prosecutor objects, and the judge will decide. This is their time. That's why they're having a conference on the instructions. What the reason for the conference is to try to get out of any appeal issue anything that can be resolved so that the defense says satisfied with the instruction. Or if the defense is going to say, I still don't like this instruction, the judge can put on the record so that an appellate lawyer can see what the reason was. The judge can put on the record why she is going to do something, even though there may be an objection from the defendant. What they're doing, it's partly for the appellate record. It's partly to get the instructions as clean and as satisfactory to both sides as the judge can do it.
Lest you think we are not a global phenomenon, Lewis, Carol Brenton, 74 and beautiful in Nairobi, Kenya. The sun is setting, and down under, it's summer, hot and humid and sweaty. So interesting how the internets have brought the world so close together. You feel like right now, I feel like I'm in Perth, and it's hot and humid there. -5 in Finland. Look at this. We've got people. It amazes me that we have people. And what amazes me even more is that these people all around the world, Joe Patuto, are interested in the depraved American society where violence runs rampant. So I don't know. There was a thought I just had going, as Carm would say, in one ear and out the other. I can't remember what I was going to bring up, but we are waiting for the judge here to come back any moment and sort of direct us for the rest of the day. Oh, I know what I was going to bring up. So I like to get STS Nation's feedback. So the first of the year is going to be here, 25 Celsius in Pretoria, South Africa. The first of the year will be here before you can bat an eye. And there's an interesting case in New Jersey. A guy named Paul Carnero is going on trial for murder in the murder of his brother and his sister-in-law. And he also murdered the brother's kids. I believe
God.
And then he burned the house down, and then went to his house and I believe burned his house down. Anyway, he's going on trial. It's an awful case, but it's interesting. The reason I'm thinking of going there is simultaneously, I think on the same day, the Alexander brothers trial starts in New York. The issue with the Alexander brothers trial is it's not being televised. If you don't know the Alexander brothers, they're three brothers from a very prominent Miami family. Two of them are big real estate guys worth literally hundreds of millions of dollars. They're accused of Diddy-esque crimes. There's a lot of video apparently that the feds have. It's a federal case. So I could cover Carnero in court during the day and then cover the Alexander brothers at night, and I would be in that vicinity and I could get into New York if I needed to. What do you guys think of that as a potential plan? So sort of like two trials at once, one that is being streamed from New Jersey, and then the other in the evening, we could cover the Alexander brothers. And then when there's a big day, we will stick with one or the other. Let me know your thoughts, survivingthesurvivor@gmail.com. And let me know if that's something that you guys would be interested in, because it'll be here before we even know that it is going to be here. I need to hear more about the Jersey case, and let's get Panera, as in Panera bread. I love it. Professor Joe, I asked a question. Did you not see it? That's the comment right here from Josephine.
I must not have.
Josephine asked the question again, and I'll try to get it to Joe. Do you have any questions for Joe right now? Of course, it wouldn't be a show without an arrest Wendy immediately. That I
You
don't
know,
think
did
is
I tell
happening.
you, you know, Judy Singh, who does AA Legal Focus and
Yeah.
covers the Adelsons,
Yeah.
she made a bet with someone of an arrest before New Year's Day. And her side of the bet is if Wendy is not arrested, she's going to appear on her program in a bikini.
There
So-
we go. Well, I think it's going to happen. I don't think it's going to. What I was saying is, I don't think it's going to happen before the first of the year. Mim Mom, this happened in Colts Neck, New Jersey. And by the way, this crime in New Jersey, Colts Neck is where Bruce Springsteen lives. It's a very nice area. Mim Mom or Me Mom, is that what it is? Me Mom. Let me know. I assume this is pretty big in the Colts Neck area on NJ.com. You seeing? Let me know. It's a pretty big case. Forget about, or she forgot. Big difference with one letter. Forgot about the Alexander brothers. I thought she said forget about the Alexander brothers. So, yeah, I'm thinking people are saying yes on the Alexander brothers. Cover the Alexander. Have you followed that case at all, Joe?
Yes.
Yeah. So I think we're gonna have to do this to some extent, somehow. Here we go. This is Josephine's question for you, Joe. Do you think he pulled a Donna Adelson and decided this morning, maybe Mommy Dearest even told him not to do it, not to testify? What are your thoughts? What do you think went down in the
I mean, it's anybody's guess. I don't know. I don't know what it means to pull a Donna Adelson. He may have decided this morning. He may have decided yesterday. He may have had this in the back of his mind all along, for all we know. Did his mother advise him? I don't know. He seems to have a close relationship with her. But, you know, I can't. The legal questions are easy for me. The sort of the trying to figure out what's in the mind of a murderer who did this kind of murder, a little more difficult.
Yeah, we need Carm for that one. This judge, Joe, usually stops 2 p.m. Last week, I think it was 1 p.m. on Fridays. Is the jury going to begin deliberations in the afternoon? I would imagine so, unless do you think that they would hear closings and then she just sends them home?
I don't. I think she will let them deliberate. She stops on Fridays at 2, I think probably to do other issues. Some judges have motions in the afternoon on Friday related to other trials and other kinds of things, maybe pleas, maybe sentencing hearings. They often do them in that free time. So if the jury is deliberating, that doesn't affect her schedule to do other things in the afternoon because they're going to be off on their own doing it. And I would think that she would want them to go start deliberating as soon as the closings are over. And if it gets to lunchtime, to have lunch first.
Someone asking about Corey Richins. That trial is at the end of February. Please follow the Alexander brothers. Want to see those monsters get put away for a very long time. I have a very strong hunch that is not going to end like Sean Combs. It's going to end with a very, very heavy sentence and a conviction for all involved there, which are the 3 brothers. I'm seeing some sort of movement, I think, on the courtroom camera. I'm not 100% sure. No, they're just moving to a different angle of the clock. If you have questions for Joe, I mean, Joe, this has come up again, but SOT 30 seconds. Where's that? Let's see here. I think this is it. Let's listen to this. This is Tipton, I believe, from openings here.
The family assets. You have to decide, how is it that I make sure, how is it, as Brian Walsh will tell you, how is it that I make sure?
Right there. He just said it. Let's go back and listen, as Brian Walsh will tell you. And look how confident he is right here. Command of the courtroom. And then when he talks to the judge, it's
And then a little sheepish.
Yeah, here we go. This is him saying Brian will testify.
Family assets. You have to decide, how is it that I make sure, how is it, as Brian Walsh will tell you, how is it that I make sure that my wife and my 3 sons are financially secure if I have to go to prison for a day, for a week, for a month, or for years. That's what they were talking about. And in all of the other digital data that the Commonwealth has been poring over for 2 years, you will not hear evidence of any other conversations about divorce. And you won't hear it.
That's interesting. He wants to be sure his children are taken care of. So the way to do it is to dismember their mother and throw her in
Yeah.
a trash dumpster.
Sounds very something only a criminal defense attorney could say with a straight face. Like imagine being at like a bar with friends and saying they'd look at you and say you're absolutely crazy, but when a criminal defense attorney in a suit and tie says it in a courtroom, you're like, oh, okay. Tipton, here we go. Barbara must be an attorney herself. Tipton did not explicitly say Brian Walshe will testify, only that we will hear from him. You could argue that hearing him on the police tapes is that, but it does heavily imply he will testify. What do you make of that, Joe? I mean, he doesn't.
No, I wouldn't read it that way. I think it's possible. And I'm trying to remember the police tapes. Did he? No, there is no police interview. Story 2. All the interviews, I think, are story 1. So it's not possible that you're going to hear this story in a police interview. So it can't mean that.
This comment.
Look, instead of watching the fan go around, we're now watching the pendulum on the clock go back and forth.
Yeah, it's mesmerizing. I might actually fall asleep. This comment warms my heart, Joel. I was reading you and Carm's book this time last year in Costa Adige. Freaking awesome read. Laughed and cried throughout. Love you and Carm's comical banter together. It is the holidays. The book will change how you see life. So pick it up, give it to a friend, give it to your mom, give it to a child, don't give it to a child because there's a lot of F-bombs in it, but give it to somebody. Joe, will the judge cite the 2 cases in the next segment? I'm not sure.
The cases that she's relying on in order to give the instruction that she's going to give on the fact that the defense opens saying that Brian Walshe would testify and providing information as to what he was going to say. She's going to give the cases to, or has I'm sure by now, to the prosecutor and to the defense. She may cite them on the record when we go back in. I would like her to do that because I could find them, but I'd have to go on Westlaw and do some searching, and she could help my research efforts if she just told us. But I don't know whether she'll put them on the record, but they certainly have them. And I'd like to add something here, and it's with regard to the defense lawyer Tipton. This is a situation or an example of why a lawyer needs to have a really strong reputation for ethical conduct, because these sorts of things happen. Defendants do things that may put you in a really awkward position. And if your reputation among judges and other lawyers is that you operate ethically, then they will give you, a lot of leeway when something like this happens. If your reputation is you run close to the line and you're willing to sort of cross it if you can get away with it, your opportunity when something goes wrong to walk unscathed or uncriticized is much lower. Your reputation also helps you with judges. If you need more time for something, the judge is more likely to do it. If the judge believes that you're a lawyer who works ethically and works hard and that something just came up, same thing with other lawyers. They're more likely to agree to a continuance or agree to something you want. So reputation matters everywhere, but certainly with regard to practicing lawyers, the fact that you have a strong reputation is really, it's money in the bank for you.
We always try to really think of the victims at STS, but you can't help it. When you're talking true crime, it's so unbelievably outrageous that you forget that these are real people. But Anna's gone, and she's obviously the biggest victim in all this. But those 3 kids who have about the same age difference as my 3 kids, I saw somewhere in the chat that they're actually apparently in Serbia with Anna's mother. I don't know if that's accurate or not, but those kids, they're going to lose a father, and they lost their mother, and their whole lives, basically forever, will be upended. I mean, think about something that your parent did to you when you were 6 or 7 years old. This is going to be something that impacts them on such a larger level for the rest of their lives. So it's beyond tragic. From Garden Girl, Joe, we talked about this a little bit, but just to underscore it, can the defense closing bring up this sudden death syndrome now, since they provided no evidence, only mentioning it in openings where it is not evidence?
Well, now that's not accurate, actually. He asked the medical examiner about sudden unexplained death. And the medical examiner did testify as to the possibility. So that is in evidence.
That was Richard Atkinson, the quirky medical examiner from the medical examiner's office in this jurisdiction. He was a quirky, interesting witness for sure. I live 10 minutes from Colts Neck, and apparently Carnero went back to his own house and set that on fire with his whole family in it. It was just an absolutely horrific crime to Jersey there. People are asking about this too. Kevin Callahan, and by the way, the judge right now, they're running about 27 minutes late. They were supposed to come back at 10:30. Originally, she said 11. The lawyer said, well, we could be back at 10:30.
And then they looked at the instructions.
Yeah.
They've got more questions than they thought they were going to have.
Exactly. Is there anybody from the victims, from Anna's family in court? Her mother's not here, and we heard from, Margaret, who was here yesterday, that really she has no one in court. The only people that are in court is Brian's mother and then the media. There's not a lot of people there, which is typically the case. You know, you think in these high-profile cases that the courtroom is going to be packed, and sometimes it is. You know, with the Adelsons, it was very full most of the time, but it was never an issue to get in or not. And that's because, a lot of people are just, they've got things to do. They're living their lives and they can't get to court. But in this case, Anna did not have a lot of representation there. Joe, I'm just wondering, what do you think that does to a juror's mind if you see family or you don't see family? Like, are they wondering why her family is not there?
I don't know. I think they know that she's from Serbia. I think the jurors definitely notice if there are a lot of people in the courtroom. And certainly they would notice if no one is there. And I assume would then think about, why isn't anybody there, representing her, in there supporting her. But they do know from at least two witnesses that she had lots of friends, and at least the two who were on the stand cared for her deeply. So.
Donna, Donna had some friends there at different portions of her trial, but it was primarily Harvey who was there overseeing what was happening in the courtroom. Brian Walshe, there we go. So true, Joel, about the children. Imagine being in your cozy bed with your toys. The next thing you know, you have no mom, no dad, and you're presumably with strangers. It's beyond unbelievable. It really is. Those kids, no kids ever deserve that. They're just caught in the proverbial crossfire there. I saw another comment here.
And they're also going to have to live the rest of their lives with the knowledge, of what happened to their mother by their father. It's awful.
Yeah. And if you're a boy or a girl, but particularly I think if you're a boy and your father is this cold, calculated killer, like, what does that do to you psychologically? I think there has to be a part of you. I know Kerry Rawson talked about this, the daughter of the BTK serial killer. There's a part of you that wonders, like, am I like my father? And that's a really, talking about going to, my dad was a psychiatrist, talking about going to a shrink for help. If your father kills people or has killed your mother, that is not an easy thing to negotiate in your own mind. In the court of law, Brian Walshe is innocent until proven guilty. Carm must have just called the COE. Carm, ever paranoid, reminds us that people are innocent until proven guilty in a court of law, and that's precisely why we are having a trial. So as of this moment, Brian Walshe, you are presumed innocent. Wink, 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 wink. Back to fantasizing about going through Home Depot and Lowe's in a full-on Tyvek suit. I just COE, give me an indication. I see you right here. Would you trail behind me with a camera, or would you make J-Mac do it? I just worry about his camera abilities at 6 years old. Who would film me, COE, going into Home Depot? I want to do it, and I want to add the snorkel. I just wanted what kind of response I would get. I think there's enough, quote unquote, ridiculous Instagram influencers that most people if I did that in New York City, no one would even turn their head, right, Joe Patuto?
I once saw a llama walking down 10th Avenue. That did catch my attention, but then I was told the circus was in town.
I like how Joe did not miss a beat. I once saw a llama walking down. I'm trying to think of like weird. There's nothing in New York City that could really surprise you or shock you, I don't think.
No, and we're better. An actor walks by and most people take a look and then walk on. We don't sort of bother them or, look closely. We're really pretty good at that sort of thing, I think. Patting myself on the back for people from this area.
The COE and I met reporting in Tucson, and I remember Tank. I'll never forget Tank, and Tank is probably still alive. Tank was a tortoise who lives in downtown Tucson. Whenever you do stories down there, he belonged to like a homeless guy, and he would always follow that homeless guy. But he'd be like 100 yards apart. So you'd be doing a story, and you'd hear this creaking on like the dry desert sidewalk. You'd hear ksh, 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 ksh. And then you look over and it was Tank walking your way. At the time, I think he was in his 90s, but they lived to like 180 years old, and he was just massive tortoise just walking around Tucson, by the way. And I say this with all due respect and love, because I really love Tucson. It is got to be the weirdest place, maybe on planet Earth, but definitely in America. The desert is a very, very, very weird place. It attracts very weird people, very weird vibe.
It's because it's warm. People may be weird, but they gravitate, particularly those who are homeless, gravitate there. I lived in Tucson and loved it.
Oh, you did?
I taught at the University of Arizona for a semester. They wanted me to visit for a year, and I don't know whether I don't even know now whether I could have stayed if I wanted, but I couldn't believe that I'd want to be there. I didn't know it for more than a semester. So I went for a semester and absolutely loved it.
I like to hear that. Is there anything more different than New Jersey than Tucson? When I went to Tucson, I thought it was going to be like a cobblestone main street with like horses, like in a Western. And for those who don't know, Tucson is this massive, it's like 250 square miles or so. It goes on forever. And look at this, Tucson 80 today, like yesterday. Give a shout out to my friend Matt Brode, a meteorologist at the local NBC KVOA. The only meteorologist that despises warm weather and craves snow, and he works in a market where it's sunny like 363 years. Look at this, Joe Patuto. I know Tank from Tucson. Tank is famous in Tucson, and I'm sure he is still alive. But I'm happy but surprised that you love Tucson, Joe.
I did. Different. I love cowboy stuff. I'd watch a Western. I mean, I'm sorry they don't make them anymore. I really got it. I went to one of those, I don't know what they call them now, where I don't remember, they were kind of the dramas where they do this silly, what are they called? the over dramatic little stories, and I got a real kick out of that. I went to Old Tucson, which was the set of the Westerns where John Wayne made a lot of his Westerns. Yeah, I really liked it a lot.
Did you live downtown or did you live like in the foothills?
No, I lived near where Mount Lemon was, so it was a little outside where Sabino Canyon, where you would go into Sabino Canyon.
That's where I lived. That's where I
Yeah.
lived. Wow,
Yeah.
look at that. I had no idea till this very
Yeah.
moment. What about that?
Yeah, I really liked it. I liked the people. I didn't like the heat. And when I left on Memorial Day, and it was already with 99, 100, and one of my uncles had said to me when I complained about the heat, but at least it's dry heat. And I remember saying to him, "So is an oven. Would you like to sit in it all day?"
Exactly. This is true, by the way. I interviewed
Remember
a
the
cow.
Commonwealth versus Brian Walsh, indictment 2023-0091.
All right. Let me make some space over here. So I know you haven't had a long time to look at them, but we'll take a stab at seeing how far we can get today, and then we'll reassess whether we need to charge conference a little bit more tomorrow. All right. So my approach to charge conferences is pretty informal. And so what I'll ask for each of you to each side is, based on your initial review of the draft, where's the first page that you wish to either bring something to my attention because you either don't want it in there or you want it in a different way? So an edit or an extraction or an addition. What's the first page for the Commonwealth?
Your Honor, I'd say page 15 going into 16, the impeachment by prior conviction.
All right, stop right there. And does the defense have anything before page 15?
We've got the appellate lawyer there
One?
again.
I think it is. She just took it.
That's who that is.
No. It's,
Yeah.
sorry.
She's the one, I'm sure, who does motion. She did the law the other
I'm sorry, I
day.
got one here, but I meant what my notes are saying. It's paragraph 1.
I said page 1 is the index. Actually, it's not really page 1.
Oh, we need it forever if we were starting with page.
All right, so what page?
Page, lodging my objection, Judge, to, otherwise the instruction complies, in my opinion, with the model jury. I'm renewing my request for my modification that I filed on behalf of defendant's request for jury instructions concerning consciousness of guilt, emotional evidence, and bad acts. Paragraph 1, I am asking that the section be regarding the timing of premeditation be removed for the reasons I stated in the motion.
All right, I read your motion. Denying your request to make the change. As you know, if I agreed with you, I guess the underlying premise that I thought there was something wrong with that instruction, I agree with you. These are just model instructions. Now, they're model instructions that people have spent, I don't know, countless hours assessing the propriety of, but I don't think that that instruction is improper in any way. I think it's a proper instruction, and it's one that ought to be given in this case. So I won't modify the model SJC instruction with regard to the request, but it's been fully preserved for the appeals court if they decide to change the instruction.
Thank you, Judge.
Mm-hmm. So 15 on to 16. Anything from the defense before page 15, other than what you just mentioned?
Page 9,
Yes, counsel.
the instruction, parentheses B,
Yes.
use of a dangerous weapon.
Okay.
I think that's in the context and circumstances of this case, that instruction is very prejudicial and misleading. There is no evidence, no direct evidence or circumstantial evidence that there was a weapon used
that caused the death of Anna Walshe. And so what the jury is being allowed to do.
What about the breadcrumbs that the Commonwealth put down?
What, the breadcrumbs?
Well, why don't you argue and then I'll let them I don't want to make their argument for them. That would be, but I want to get to the right answer. So go ahead and you argue and then they'll argue and then we'll have an opportunity to rebut.
Everyone
I understand
argued.
the admission of the exhibits. I understand the admission of the hacksaw, but to suggest to the jury that they can just pick and choose whatever, quote, weapon, even if you can define it that, and just speculate as to, well, this was used, this wasn't used, that is requiring the jury to speculate that a weapon was in fact, in the first instance, that a weapon was in fact used when there's no evidence of that. And secondly, to speculate that some of the evidence that was introduced might have been a weapon that was used without any evidence that in fact it was. And given the state of this evidence, this instruction invites the jury to speculate without sufficient evidence to reach its conclusion. And I would ask that it be removed because all it does, well, I'm repeating myself. I'll leave it at that.
All right, Commonwealth.
Your Honor, it suggests from the evidence it's a reasonable inference based on the safari history and the searches were using a dishwasher to remove DNA. One can infer that an object was used, a dangerous weapon was used to murder Anna Walshe. There's also the evidence of the defendant's trip to the Vin and Liquors dumpster when the liquor store was closed. I believe the manager of the liquor store identified it as the defendant throwing that bag in the dumpster. That's prior to the trip to Lowe's or any of the stores where he purchased the materials. I would suggest it's a reasonable inference that a dangerous weapon was used here and would ask that the court keep that instruction in.
What about the hair on the hammer? I would say that too.
Music say DNA on the knife.
No, she didn't say that because there is no DNA on the knife, right?
That's correct, Your Honor.
So, but I did hear you say knife, didn't I?
Knife. I didn't hear her say knife just now.
There was a search.
There is a knife above the.
There is a knife, but there is also a search in the web history in the defendant's.
I remember that. And then
regarding
the search was specific as I recall it, and remind me if my memory is wrong. Is the search with regard to the dishwasher specific to a knife?
Your Honor, may I? I believe that I can answer this question. There is a slate.com article
Right.
that the defendant went to that was regarding can DNA be removed from a knife?
Yes.
Then the dishwasher is
Following that, right?
it follows that, and it's can the dishwasher, and I'm just trying to find the exact words.
Give me the page number on I think it's Exhibit 79. Is that right?
It's Exhibit 79.
All right.
And then page number 4, the DNA off of a knife,
Yes.
is page 578.
Let me get there.
Okay.
I'm there.
Okay. Then if you go to page 670,
Hold on. I just want to look at these.
sure, I apologize.
How long does DNA last? Is it possible for DNA to take clean DNA off of a knife? And that's done on 1/1/23 at 9:34 a.m.
Yes, Your Honor.
Okay, and just putting all this evidence together, when was the Vinton's Liquor is also on the first, it's at night, because I remember it being a little dark. What
yes,
time is
Your
that?
Honor. It's dark at at Vin and Liquors.
5:30, 4:30,
About
something like
5
that?
p.m., Your Honor.
All right. Okay,
And so if you were to go to page 670,
yeah, let me get there. Yes.
and if you were to go to record 2430,
Does the dishwasher clean blood?
yes, Your Honor.
That's at 1/1 at 1:52, also before the,
Been in liquors.
right,
And then on page 671, there is record 2433. Is it possible that a knife
Contaminated with HIV after it's been washed with hot water and dishwasher soap.
Yes, Your Honor.
Mm-hmm.
And so,
I'm above it. Does a dishwasher clean blood?
yes, Your Honor.
I think there was hair, clumps
So,
of hair with
I think
blood on
earlier you
the
referred
hammer.
to breadcrumbs.
That's what I said.
And so our position would be it's a reasonable inference based on the searches, the behavior of going to Vin and Liquors, and then this is all before the Lowe's trip where the other articles are bought for the purposes of the dismemberment. And if you look into the searches on the second, it's instructions on how to dismember. So there I see the way, what our argument is that those searches show the reasonable inference that a weapon was used.
All right. There are the breadcrumbs. Attorney Tipton, back to you.
Well, I'm not going to repeat what I said. I understand the breadcrumbs argument. However, I would ask then, I think I see the writing on the wall, that the instruction will remain, but I would ask then, to be fair and balanced, that a sentence be added, that you are not to speculate about whether a knife was used, or words to that effect, to help guide the jury to avoid speculating about any and all of the tools and weapons, so-called weapons. I just think the jury's going to think, oh, I can cherry pick whatever I want to and call it a weapon and use it to find the defendant guilty of first-degree murder. And I'm trying to make sure that the jury does not get such a broad instruction that allows them to speculate. So I'll leave it at that.
Well, I'll give some more thought about whether I add some language in there with regard to speculation. And if you wish, you can provide me with some recommended language. But as you know, the whole issue with speculation is handled quite completely in other parts of the instruction. But I'll think about it.
I will send the court, if it's okay, I'll send an email to the court today with suggested language.
All right. As of this time, the instruction is going in and subject to any additional edits. But I think there's enough there that the Commonwealth has presented, as I said, the breadcrumbs. Which, this case is what it is. It's been a circumstantial case from the beginning. And so those breadcrumbs are important for the Commonwealth's case. And I think they've properly established it to a sufficient degree to get this instruction about use of a dangerous weapon. But I'm also mindful of what you say. I'll go back and look at the section about the prohibition against any speculation or guesswork and see if I feel like it accurately and completely addresses those concerns. And I'll be open to seeing whether there's something else that needs to be added to make it more easy for the jury to digest this aspect. That's all I can say right now. All right. We're still at the defense. Anything else before page 15?
No.
All right, so now we'll move to the other side. What is your, I'm moving to page 15. Did you say 15 into 16?
The impeachment by prior conviction?
Yes.
And
I guess I lifted part of this language from the defense's request.
Your Honor, this appears to have language suggesting a testifying person being impeached.
That's probably because when the defense, I lifted it from your instructions and at a time when I think that was the expectation, but let me go back.
The lawyer testifying also was the one who did the argument against the motion to dismiss at the end of the Commonwealth's case. So I'm guessing
Well,
she's.
that first sentence, they have heard evidence through stipulation, right? Is it later than that I only read the first sentence so far. You've heard evidence, they have through stipulation, right?
Yes, Your Honor,
That sentence is okay.
it's on the next page only for the limited purpose. And I suggested
I see,
limited
I
purpose.
see, I see.
Jury instructions are important because these are the basis of a lot of appeals. Because if you don't instruct the jury properly on the law,
Does the whole thing come out?
Your Honor, I note in Commonwealth's motion in limine number 12, paper 198, the Commonwealth laid out the purpose for which it was seeking to bring in the evidence of the federal charge. Perhaps that language from that could be substituted, as you may only consider this evidence to understand the relationship between the defendant and the victim, or something of that nature, to understand complete circumstances of the situation in the home at the time of the events at issue here.
Well, I
she
like
should have
that.
had
I think, Your Honor, the model instructions all do seem to include, you may only use this for the limited purpose of, and I suggest they should be given a purpose and.
Well, but it's not impeachment. I mean, I did put that in there last night based on the information I had at that time. But that prior felony conviction is no longer impeaching Mr. Walsh. So it just seems to me like it should be out.
We think it should be out.
Then maybe it should be out.
I mean, it's no longer impeaching him, and the relevance of the prior federal conviction goes to motive intent, it seems to me, right?
Your Honor, I suggest there were reasons it was introduced to understand the relationship in the home as way of a shorthand. So, but I agree, it is not impeachment evidence.
All right. My present ruling is that's whole section's coming out now. The reason the impeachment by prior inconsistent statement is now in italics is I'm sure that happened with some witness, but I'm not 100% sure.
I don't think it did. At least.
Anybody?
I want to speak.
Your Honor, I think some witnesses may have testified a little bit differently than they had previously and were shown documents. I don't know that it rose to the level of impeachment, but there was some questioning of some witnesses about something they had said
Yeah, I
previously.
just don't think that we ever got to a statement. I don't remember anybody grabbing a grand jury transcript and cross-examining. The closest we got to it, I think, was Jem yesterday, Mr. Mutlu yesterday, and that wasn't with a prior statement. It was his prior statement, but he just said, I don't remember. So is that enough to warrant the instruction?
Certainly, if the defense wants it out, we agree we should take that out.
I don't need to give them more instructions that they're wondering, what the heck is she talking about?
I
So
wondered
I'm
when I
inclined to
heard
take it
that.
out.
And we have no objections.
All right, that's why it was in italics before.
Your Honor, then the impeachment by defendant's prior bad act.
Yes.
With this, I would suggest that the lying and the conveying of the body are part and parcel of the murder at this point. It's the disposal of the evidence of the crime and the lying about what he had done. I would suggest it's not a prior bad act. It's part of the evidence of the case.
It's an interesting question.
There's many interesting questions in this case, Your Honor, no doubt.
It's an interesting question whether, where are you drawing the line of a prior bad act occurring? Can you have a prior bad act that's part and parcel? Is it prior to this time? Is it prior to the crime that was charged?
It's arguably subsequent, Your Honor, but,
Right.
I mean, it's arguably,
What about the lying to his federal probation officer?
that would appear to be a bad act, arguably a subsequent bad act, but,
Yes.
I don't want to interrupt. I tried to address what I believe are pleading at page 6. And I took it from the Massachusetts Jury Trial Bench Book, and I modified it only to accommodate what I believe is relevant and pertinent. And the gist of that model instruction is to make sure that the jury, if they hear what they consider to be bad, and I frame our instruction as prior and subsequent bad acts, that he's not charged with those, and that they have to, just like the model instruction says, if they deem those to be bad or subsequent bad acts, they can only use them for a limited purpose. And I think that this jury will probably be asking themselves, I don't know who in the world wouldn't ask themselves, that's a bad thing to do, if they believe that the body was dismembered, and if they believe that the body was disposed of in bags. Anybody's going to think that's a bad act. And they need to be instructed that they can't, he was not charged with anything, and therefore they can only use that evidence in a limited basis. And I don't much care for the specific language of motive or anything, but it is the model instruction. And I think I would try to parse.
So I'm looking at your instruction right now, and that deals with the art fraud, right? Are we on the same page,
Yes,
Attorney Tipton?
yeah.
But are you suggesting, I just want to make sure I understand what the respective positions are. Are you suggesting then that you want to expand that, so you want an instruction to the jury that includes the language that I have in there, which is lying to the police and disposing of the body of Anna Walshe?
Well,
and the lying to the probate. So that's not what's in here, but are you saying do what you did, Judge, in the instruction, but add what I want in instruction 6? Is that what you're telling me?
yes.
Okay.
But
Do you want that to be included? So in the proposed instruction, and so the record's sort of clear, I'm talking about the defendant's request for jury instructions concerning consciousness of guilt, emotional evidence, and bad acts. I don't know what the docket number is, but I got that. It was filed yesterday, December 10th. And I'm looking in particular at your request number 4, prior and subsequent bad acts. That's what you were referring to, Attorney Tipton. Okay, and so in that, as you initially drafted it yesterday, it was about the art fraud, but you're now suggesting that that would be an appropriate instruction also for the other bad acts that I've identified in my draft on page 17 under impeachment.
yes, Your Honor, I was anticipating there to be a proposed other instruction like you had, but yes,
Okay.
I would ask then that.
So I think I understand what the ask is now.
Right.
And so now I'll go to the Commonwealth.
Your Honor, I think I understand it better as well. It also says in the instruction about the middle of it, if you credit the statement, I don't know that we're specifically talking about a statement here. And maybe that could be expanded if the court is inclined to keep that instruction in.
Well, I think the language comes in that defendant hasn't been charged with committing any other crimes other than murder. I'm just pausing there because if I move the federal art conviction in, somebody could wordsmith that and says, oh, yes, he pled guilty to a federal crime. Maybe the better way to say it is the only charge you need to consider is the present charge of murder.
Shouldn't
I'm
draft
looking at
on
the
the fly.
first sentence.
Yes.
Not a good way to do it. They should think about it
Let me
and
take a minute.
draft. This should not, they need to come back to this tomorrow. Drafting on the fly is dangerous. You know, it's an interesting question whether the jury, if it's got a murder charge, would say and doesn't know that you can have a charge of dismembering a body or moving a body, would know that and would simply think that's all part and parcel of the murder charge. Because my guess is that's what the jury would think. It wouldn't think
All
that there
right, so if
could
I
be.
say something along the lines of, the only charge the defendant is now facing is the charge of murder.
I would take out the now.
You've heard mention of other acts allegedly done by the defendant, namely, and I wrote a few things in there, and it would seem to me what the defense is asking is that I add, the language that you have in your request was including acts involving a federal case concerning art fraud that he was charged with in 2018 and sentenced in 2024, comma, I'll just put them in date orders, right? Lying to the police and or disposing of the body of Anna Walshe and or lying to his federal probation. So all four things would go into that parenthetical.
Good.
Bad hair day for Brian, by the way.
Okay. And then, then I would pick up with what the defense has. You may not take the defendant's prior acts as substitute proof for that they committed the crime charged, nor may you consider them as proof the defendant has a criminal personality or bad character. And then the rest of that, you see that all there. All right. What do you think about that, Kamala?
Will the court be removing the, but if you credit the statement sentence?
Yeah, no, what I would do is, I'd make the change that the only charge the defendant is now facing is the charge of murder. You've heard mention of other acts allegedly done by the defendant, namely, and then I would go to the defense's suggestion, namely, acts involving a federal case concerning art fraud and that he was charged with in 2018 and sentenced in 2024, semicolon, lying to the police, semicolon, and or disposing of the body of Anna Walshe, semicolon, and or lying to his federal probation officer, end parentheses. Then pick up with the defense's request and follow that through the end. You may not take blah, 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 right through to, it would be extremely unfair to consider this evidence for those purposes. That's where I think I'll end it.
So you're not,
Then I go back. I don't think that's appropriate to add the for one thing.
the last two sentences?
That's right.
I will just say, Judge, that those sentences are contained in the model instruction at page 343.
I'll take a look at it, but it seems to me then if I put that thing in there, then I've got to,
Drafting on the
I don't know what I
fly.
do about the other things
Bad idea.
because you can see the issue that raises.
Your Honor, there's also the possibility that maybe this instruction should be given around the same time as the consciousness of guilt, because it almost seems, I don't have them both right in front of me, but it almost seems like we might be telling the jury different things about how they can handle the evidence of lying to police and the conveying of the body of Anna Walshe.
Well, that consciousness of guilt is before here, isn't it? Maybe.
I believe it's on page 27.
Oh. Well, I had this all in this section because I thought I'll put the 3 impeachment things, but now 2 of them are gone. So it doesn't make any sense, I suppose, standing alone. Maybe we just go straight from witness credibility to experts, which makes more sense, and move this impeachment paragraph later in the instruction. What do we think about putting it either around the vicinity of the consciousness of guilt instruction?
Well, my comment would be I'm objecting to the consciousness of guilt, so
I know you are. I know you are. It seems to make more sense in that area. So I'm going to move it probably before or after the consciousness of guilt instruction, somewhere in that vicinity. And if you have any strong preferences, you let me know when we get down to page 27, recognizing you don't want it at all. But I'll edit the impeachment to include a substantial portion of what the defense has requested and add in specifically the federal case. That's all I can tell you for now. We can to be continued on tomorrow if we need to discuss it more.
and I understand the court's not going to include the last 2 sentences, so I'll just lodge my objection.
Okay. So lodged. What's the next edit that the Commonwealth has?
Commonwealth has page 27.
What's the next edit the defense has?
27.
Nobody likes penny 27. What did I do on? Let us see.
He's continuing his
Okay.
objections. He has to.
That's
for the
DOJ.
record on appeal. He being the defense lawyer.
Who wants to go first with what I got wrong?
Your Honor, I would suggest here in the italicized language,
Yes.
in the course of the trial, there was some evidence suggesting that the defendant may have intentionally made certain false statements before his arrest, and that he may have taken steps to conceal the disposal of Anna Walsh's body. I would just suggest that should be tried to conceal the disposal of Anna Walsh's body. And in the
Well, the fact that it was unsuccessful is something you can argue. I mean, there is some evidence that he may have taken steps, right? That's not inaccurate.
correct, Your Honor, that's accurate.
What do you want me to add?
I was thinking you could subtract some words and perhaps make it more concise, but that is certainly
All right, so
accurate.
what do you want me to subtract?
Rather than saying taking steps to conceal the disposal of Anna Walsh's body, it's tried to conceal Anna Walsh's body. It's not so much that he was concealing the disposal of it. He was.
It's true.
Very, very detail oriented here, but good
Well,
point.
So you want me to taking steps to
And
conceal
disposal
Anna Walsh's body after death?
Yes, Your Honor, because it's the body itself. It's not so much the concealment of the body, but it's the steps to.
To conceal the
Disposal
body,
of it,
not the
yes.
disposal of the body.
Yes, Your Honor.
All right, that's probably more accurate.
Yep.
So under the Commonwealth's request, I would delete the 3 words, the disposal of.
Will you add the word tried?
What do you want me to add?
Tried. I thought I heard the Commonwealth asking for tried.
She was substituting, not adding.
Commonwealth's content with how the court articulated the.
Well, attempted to take steps might be consistent with the evidence, but then that puts my thumb on it a little bit because it presumes that that was evidence of her body.
All I was to was the Commonwealth suggested the word tried. I think that is more consistent with what the evidence shows. I'm just talking about tried. not waiving any argument to the conscience.
All right, I'm going to leave it like it is with the removal of the disposal of. I don't like the tried part.
In the next paragraph, Your Honor, in the italicized, defendant did attempt to provide false information. I believe it would be did provide false information.
That's true too.
And there I got the language right in the second attempt in terms of what you just pointed out in the earlier paragraph. Even a blind squirrel finds an. All right. Any other edits to that consciousness of guilt instruction? Recognizing the defendant doesn't want it and that objection is noted and lodged.
Are you done?
I think she's done.
So, once again, I refer to our prior pleading. And
Welcome, Stanley. Thank you.
Mm-hmm.
on page 4,
Yes.
I'm asking that I modeled that trying to find the citation. I modeled that after what I believe to be the gist of a supplemental instruction 9:22, and it's a district court. And the heading for that supplemental instruction that's included refers to where evidence is of it, where such evidence is of another crime. It goes on to say, I caution you in considering such evidence that the defendant is not on trial for, then it has a blank intent,
Right.
and that's what I do.
But now that I'm moving down the other section that we just discussed, which far more in a more detailed fashion addresses that.
You mean in the prior?
Yes, because now that's going to sit right on top of this one.
Well, but I think that the reason I'm pressing this, notwithstanding this other instruction, because I think just the title alone draws attention to the jury where they're hearing a different instruction entitled consciousness of guilt.
Mm-hmm.
And I don't know that jury will take some language from a prior instruction and import it into this one. And it's important for them, in our opinion, to have context for how they use so-called consciousness of guilt evidence. And the other thing is, when you talk about consciousness of guilt evidence, the case law is clear and the instruction says they can't rely on consciousness of guilt evidence alone. And I think it then, since we don't want the instruction in the first instance, at least it gives them better context for how to apply what they may deem to be conscious of guilt evidence, especially where you hear all of these other acts. And yes, they will get the prior bad acts if you juxtapose it before this instruction.
I actually think it's better right after it, as I'm thinking about it, because it leaves them with it puts them in that moment, and then you may not use it for this purpose. As you were arguing, I'm like, that's not going before, it should go after.
Right.
Because
I'm just pressing this supplement primarily based on this Model 9.
I'll go back and look at it, and I'm going to see how it feels once I've moved things around and how it reads. All right.
Okay.
And of course, you know this is coming, so you will, I am sure, as you all, I know you will. You're going to take those parts of my instructions that you want to highlight to the jury and put them in part of your closing arguments. And so you'll know where it is and you can point directly to it so that you highlight. I'm going to tell them, take all my instructions as a whole. You're going to drill them into the ones that you think best suits your client's argument, including this one. But anyway,
I may, but
or not.
having said that, I guess I just want to ask a question.
Yes.
Does the court intend to supply written instructions to me?
So what I do is I don't give them a written instruction during the actual charge. And there's a very simple, I'm a very practical person. I've been sitting on the bench now since 2017. And not once, and I'm not proud of this. There are other judges that do a better job at this. There's not once, no matter how many times I read this, no matter how many times you read it, there's always a wayward S that sticks in there, charges instead of charge, or some other less than perfect product as I read it. And I edit those on the fly, and I tell them, typically, it's my oral instructions, not what you put in the writing. I've never had something that's been a huge guffaw, but it could happen. I don't think it's going to happen in this case, but I don't finalize those instructions until after I've read it to them, made those edits. I sort of a running game I have with myself. When are you going to get it right? Exactly right. It hasn't happened yet. I don't know that it's going to happen on this case. There's always some little niggling little mistake. So I don't give it to them in writing when I'm reading it. I give them copies of the charge when the exhibits go back. And my practice has sort of varied over the years. I should just send in one because I want them around the table talking about the instructions, doing it all together. That became cumbersome, so I've now changed it. I usually send in 5 or 6 copies of the charge. If they want more, they can have more. I usually tell them that. But I won't give them, they won't be sitting in the box reading the charge with me. That's not how I do it. And that's the practical reason why I don't do it. I don't want to be backpedaling. I want to give them the best product, both orally and in writing, that I can give them. So if that answers your question, that's how we'll do it. Now, you'll obviously have the draft so you can read along. And I encourage you to point out my errors despite my best efforts. You'll see me up there marking it up as I always do. Maybe tomorrow will be the case that I get it all right. Still trying. All right, what's the next page?
Your Honor, for the Commonwealth, not so much a page, but circumstantial evidence. I know the court has direct and indirect evidence in there at 23. Would the court consider also including circumstantial evidence in that?
What page you on?
Page 23?
Well, this is the plain language version of the circumstantial evidence.
Yes, Your Honor.
I don't have strong feelings about it. If there's some language you want to propose, I have used other language that refers to things as sort of the more old-fashioned language. This is direct evidence. The mailbox postman thing, I've delivered that a number of times. I think this is the more modern version of that. But if you want to propose some language, I'm not adverse to explaining it.
I'm just
Should
objecting.
have that ready to give to the judge. She's going to make the objection. She should have her proposed language.
This is sufficient.
It just talks about it in terms of direct evidence and indirect as opposed to circumstantial. I mean, it could be as simple as adding in sometimes called circumstantial.
Yes, Your Honor. With permission of the court, could the Commonwealth submit something later today?
Sure, that'd be helpful.
And if they do, which it sounds like, excuse me, I'm going to then add, just to let the court know, an additional language as for inference that hopefully will counter what they're trying to do. But I'm just giving the court a heads up. I don't want to send you something and you ask,
How about if I just say that is indirect evidence, sometimes called circumstantial evidence, and then you don't have to do anything this weekend. I mean, not this weekend. It feels like it's the weekend. Then you don't have to do anything tonight. I'm going to suggest that, but you can do what you want.
I think that's what the prosecutor should do. It sounds like it's sufficient. Because he wants more. She just wants the jury to know it's circumstantial evidence because that's what we all
All right.
talk about. He wants to
Anything
change
else?
the instruction.
On the instructions.
Not from the Commonwealth.
All right. I really didn't mean to set off well, there's a word that comes to mind, but it wouldn't be judicial, so I won't use it. When I made my comments this morning about closing arguments. So let me just say, I was trying to stay a step ahead of you. It's not easy. And so I did start looking at this issue a couple of days ago. And I'm going to tell you what the cases I came across and sort of where my preliminary thinking is with regard to this. And maybe there isn't an issue. Maybe there is. But let me just tell you, we all know what I'm talking about, right?
Yes.
All right. So
What was that?
I'm going to give you some cites to some cases, and I'm going to tell you preliminarily where I think the line drawing is. And it's really preliminary because I looked at these like 4 days ago. Oh, Tuesday, December 9th. So I guess it was just yesterday.
2 days ago.
Well, no, that's not exactly when I looked at them. I think I looked at them this week and I sent them to my law clerk on Tuesday, December 9th, or vice versa. So anyway, here are the cases that I want you to take a look at. 2019, Commonwealth versus Ahern, 96 Mass App Court, 197. And that cites to Commonwealth versus Nelson, 468 Mass 1, a 2014 case from the SJC. And I also want you looking at Commonwealth versus Tavares, 27 Mass Appellate Court, 637. And in those cases, the SJC and or the appeals court is really talking about this issue of improper burden shifting and avoiding that in closing arguments. And really, it seems to me the one that's the closest to this is a combination of Ahern and Nelson. And look at those cases. I'm not going to get into a detailed description of what I think the similarities are to those cases. You're going to see it when you read those cases. But it seems to me preliminarily that while the Commonwealth should not comment that the defendant didn't testify, that would be improper. It seems to me that they could point out that there's no evidence that Anna died of any natural causes. I read the pleadings that just came through. And if that is where the line is drawn, you don't have to respond to this right now. I'm not, and frankly, the pleadings that just came through, I mean literally the ones that came through before the defense filed right before I went on the bench. I'm not sure or the allegations of reneging on a promise are impacted. But qualify that by saying I read the pleading quickly and thought to myself, well, I didn't mean to start that. Going back to how I opened this discussion. So that's where I think the line is drawn by those cases. And knowing that's where I sort of am drawing the line, take a look at those cases and we'll discuss it again before the before the closing arguments.
Thank you, Your Honor.
Just to be clear, I think and we'll read the cases, but what the court's saying is that you would think the Commonwealth could comment that something about
There is no evidence that Anna Walsh died of natural causes.
And of course the defendant can make I just want to be clear about this because I think we might reach some common ground here.
That's what I'm trying to achieve.
And I'm responding to something that the Commonwealth represented. I'm not going to go into right now. So let's just stick to this, if we may. So if the government's allowed to say what I just said, and of course the defendant can argue there's no evidence that there was any homicide or any.
Expect you're going to.
I shouldn't be here, I suppose, but I can once again recite the evidence of sudden unexpected death that came into evidence.
That's a little complicated because there's absolutely none of that ties it to Anna Walsh. There's no testimony before this jury that ties sudden unexpected death to Anna Walsh, is there?
Well, when the court asked me that, my response is the government's case is, using that phrase you like to use, defense attorneys like to use, it's built on a house of cards suggesting that a homicide occurred without any direct evidence of a homicide. And so another causation of death should be fair game to argue because it's equally consistent. And citing the Eremos and Prof, if you have two equally inconsistent propositions, neither have been proved by reasonable doubt. That there is no direct evidence of a homicide. And building on that, we've always said there's no direct evidence that anything that came into evidence, the acts of disposal, the acts of the use of tools, occurred after the death of Ms. Walsh. So why is it that the Commonwealth is allowed to ask the jury to speculate based on their circumstantial evidence? And I shouldn't use the word speculate. Reach some conclusion based on nothing more than circumstantial when there's no direct evidence of a homicide. And we can't,
They can met out their burden with that circumstance. The law is clear there. They can met out their burden purely with circumstantial evidence. They can. And their circumstantial evidence with regard to the death, again, are those breadcrumbs and what they're going to argue those breadcrumbs mean from the searches to the evidence retrieved from the bags and other, the other distinctions in the evidence.
All of which, Judge, as we've always argued and we will continue to argue, came after any death. And so the issue is, what is the manner of death? And we now have evidence that from their own medical examiner, that death can occur suddenly, unexpectedly, without injury. And it's up for the jury to decide if they can. What evidence do they have as to manner of death when the real possibility, if not probability, is sudden unexpected death due to natural causes, as Dr. Atkinson testified to. And it's equally inconsistent with a homicide. All we're saying is they don't have any direct evidence of homicide. So why do they get to argue it based on their circumstantial evidence when their circumstantial evidence really might only speak to conduct post-death where the death was not a homicide. They haven't.
But there's evidence in the record before this jury that
I don't want to interrupt Coach thought process, but there was no objection whatsoever to the entire cross-examination of Dr.
Yeah, and I thought he should have.
Yeah, you said that.
It's not like we represented that, we made some representation that we will present evidence later, and so we made it.
so you can make an argument based on circumstantial evidence. That's what they're going to do in their case. I presume, I don't know what the Commonwealth's going to argue. I presume that they are going to draw a line between some of the evidence as being circumstantial evidence of things that happened before the dismemberment.
And I agree, they will.
So, for example, the slipper, the blood in the hair. I presume their argument is going to be that that happened before. That's circumstantial evidence, because once the foot covers are purchased, presumably they were purchased, there's a reasonable inference to be drawn, they were purchased to be used. And that's evidence of something that happened before.
I think that's an argument.
I think that's an argument to be made based on the circumstantial evidence that's presented. But so I'm turning to you and saying, if you want to argue to the jury that there was circumstantial evidence that Anna Walshe died of some natural causes, I'm just asking, what's the circumstantial evidence upon which you base that argument?
Our argument fundamentally would be that all of the evidence that the government suggests was evidence that was created in the context of a homicide. There is no evidence that it was not created after a death. And so since the jury heard all about the not only just the possibility, but the probability that there is sudden unexpected death, that the jury needs to decide for themselves. Could it have been sudden unexpected death? And all of that evidence that the government is arguing is evidence of a homicide could be only evidence of an attempt to conceal evidence that a person, and using the language and consciousness of guilt, a person is acting in a way not out of consciousness of guilt, but out of fear or fright or anything of the sort. So why is it that given the state of this evidence, we can argue our inferences that we believe the jury is allowed to make if they so choose, and if they decide that that evidence of concealment was evidence of a man reacting innocently and not with a guilty conscience, then how did Anna Walshe die? Maybe she died a sudden, unexpected death, and he tried to conceal it out of fear or fright, as is contained in the language of the consciousness of guilt. And so the jury gets to decide. And it certainly, the thrust of that argument is there brings a reasonable doubt. And that's the evidence the jury heard.
Your Honor.
Listen, they may not want, I'm not precluding you from making that argument right now. And in fact, they probably want you to make that argument. McComo.
Sorry for interrupting, Your Honor. Your Honor, this started out with a motion that the Commonwealth not make any reference in closing to representations by counsel in opening statement.
There you go.
The Commonwealth does not intend to burden shift. The Commonwealth does not intend to refer to matters not in evidence. There certainly was testimony from the medical examiner talking about different ways people can die. The Commonwealth is certainly entitled to comment on that testimony. which is in evidence, but the Commonwealth is not going to comment on the opening statement.
All right?
And that's why I was thinking we might find common ground here.
That's interesting.
Sounds like we have.
Pardon?
Sounds like we have.
So as long as we're able to argue that a possible manner of death was sudden unexpected death, I understand that the government's going to stand up and say nonsense. And we're going to say homicide, nonsense. Have we found common ground?
I think we have.
I think we're close.
Just keep talking. I don't need to be part of this conversation. I've
Talk
directed
amongst
you to the
yourselves.
cases why I think they could say something short of commenting on your opening statement. And I've told you what I think they could say. And just be talking to one another
Thank you, Your Honor.
so that there's no surprises.
This is called having your one in your cake and eating it too,
That's true.
on the defense side.
All right.
Yeah.
And again, I did not mean to create a whirlwind of activity by my comments. I just think that the idea that they couldn't comment at all about the state of the evidence, I didn't want to leave it there. And maybe the takeaway is I should stop thinking about these things 3 or 4 days before they're going to happen. But you have the cases now. All right. Take a look at the verdict slip. It looks very straightforward to me. I don't think that there's going to be any edits or changes to it. Again, I'll finalize that at the very end, so you'll have plenty of time between now and then to look at it. How long are the parties thinking they're going to need for closing arguments?
9 hours.
45 minutes.
All right.
Sounds good, Your Honor.
So 45 it is. I won't cut you off in a case like this, of course. I have cut off cases when it's a 2-day case and we're at 45, 47, but that isn't this case. And, but just, I know you'll all have a ton of experience, but 45 minutes is about as much as they can take effectively, in my view. So let's try to keep it to that. Well, we will be getting them fresh in the morning, which is good. As opposed to having, hours of evidence in the bank and they're already tired. That's all I have on my agenda. Anything that you need?
Your Honor, would the parties have an opportunity to see the next draft of the court's instructions?
Yep.
Yes. So I will be going back and editing as consistent with what we discussed. And I will then create a new draft and that will go out to you this afternoon.
Thank you.
And if I know that maybe there's some other language you want, I'll consider putting that in the morning. So maybe 8:45 tomorrow so that when the jury comes in, we don't have a big delay if we need to make any changes.
So starting at 8:45.
I think that's it. All right. Thank you. One other thing that I want to say is that you can be seated. I very much appreciate the work that you've done in the case to get the case in and tried efficiently on both sides. You picked what you needed to pick as your positions, and I appreciate the professionalism that you've shown on both sides in working with each other. And as I say, I drop into Norfolk County every once in a while as I drop into other counties. You and I, counsel, and I know that this is pretty much the routine of how the courts in the Commonwealth of Massachusetts operate day to day. There's nothing unusual about this case. The level at which you perform is the level at which I see when I travel county to county. And I appreciate the work that you've done on this case and will continue to do on this case.
Thank you.
Thank you.
All rise.
Class
there
act
were-
judge.
yeah.
Yeah.
was
Let
gonna
us
say-
have it, Joe.
Yeah, there were a couple of comments in the chat that are really, they're sort of, I would call them almost housekeeping, but I thought I'd refer to them. One of them was that I had said that I thought the judge was really on task and worked worked quickly and efficiently, but I said here that they were going too fast. And what I really was saying is drafting on the fly is a bad idea because you don't get a chance to back up and reflect and see what the language is and how the language fits in with everything else. Here it would be the instruction. And drafting by a committee is even harder. So, and that's all I was talking about. And she's going to give them a chance tomorrow to look at it again, which is what they need to do, because what they were doing now was too fast, too quick, and too everybody participating. And so that was the reference that I had to that. It's never a good idea.
The
but
woman,
it's need it.
the woman arguing for the Commonwealth, what is her role? Because she
Yeah,
obviously.
I don't know whether she works for the county or she's from the AG's office, but she pretty clearly is not someone who's doing trials. She handles the legal issues. So I called her appellate. She may be somebody in that office who handles the appeal. Some jurisdictions have someone in the office do the appeal rather than the Attorney General's office. She may be someone who does all the kind of the legal motions and arguments, like the motion to dismiss at the end. But that's what she's doing. She's not doing the trial. She's putting together the legal arguments. And so she was in yesterday. She came in today. She'll probably be with them tomorrow when they're looking at the jury instructions. And then there was another question that from someone who said she had never seen, or he had never seen, this conversation about the language of the jury instructions. It is always done because the jury instructions are a really fertile ground for a defendant to make an appeal and to prevail, because if the instruction given to the jury is wrong, then the decision by the jury is always suspect. Now, sometimes it's not a material error, and it won't result in a reversal, but this is fertile ground for getting a reversal on appeal. So what is always done is there is a conversation between defense and prosecution in front of the judge with regard to issues that one side or the other sees. Now, it's theoretically possible they could do it all in writing. The judge gives them the instructions, they look at them, they give the judge their written comments or objections, but usually it's done this way so that there's an opportunity for some back and forth on it. So those are the kinds of the questions that are not directly related to this case that I saw in the chat that I wanted to at least address.
Yeah. By the way, if you're just joining or joining late, Brian Walshe has decided not to testify in his own defense. Also, the defense called no witnesses, so they rested their case in chief. And tomorrow, closings will begin at 8:45 in the morning, 45 minutes for each side, and then presumably they will go into deliberations. I think we're going to get a verdict tomorrow. Someone, Bruce West, just said, and listen, I think there's always this apprehension. He said, "Oh, this is this is a different comment." But Bruce also said he has reasonable doubt. What they were arguing, I had a thought, Joe. The more you kind of despise a criminal defense attorney, it might be an indicator that they're actually doing a good job, because what he was doing, Tipton, was essentially saying, if they can argue homicide, why can't we argue sudden death? And that's where the judge was saying, well, look, with the homicide, there's all these factors that came in, circumstantial evidence, but no one spoke specifically to sudden death as being evidence of how she left this world. But I can see the point he's making, because there is nothing definitive to say that this is a homicide. I mean, I think it comes up a little short because you've got those Google searches where the word murder is mentioned. And I think that might be what tips this in favor of a conviction here. But it was interesting, and people were getting really annoyed with him. Is it because he was making a good argument?
Well, I found it a little annoying because we start out, I think, being unfair to the prosecutor because of what he did in opening, which introduce things that are not in evidence that the jury heard. And then he tries to get in the, he asks that medical examiner some questions about sudden unexpected death, certainly. But what he now wants to do, and I said this is like having your cake and eating it too, he now wants to be able to argue sudden unexpected death, even though he didn't put on any evidence with regard to sudden unexpected death. That's what he's trying to do. Didn't put on a case. He didn't put in any evidence on it. He didn't have the defendant on the stand who would have then connected and given him a hook for making his argument. So he then says, well, it's in because of what the prosecutor did, and the prosecutor is going to argue that these things mean murder. We should be able to argue it means sudden unexpected death. And I think that's a bridge too far. And if the prosecutor hadn't sort of agreed, I think the judge would have stood her ground on this, and he would not have been able to argue it. I think if I read it correctly, that the prosecutor is willing to say, you can argue that there is not enough evidence to show that it was homicide, without particularizing and saying, you can look at what happened and it's sudden unexpected death, because that's the piece that they didn't put in evidence. And it's not tied. And that's what the judge said. There may be this syndrome. Sure. There's also appendicitis. There's also dying of cancer, but there's nothing that ties that to Anna Walshe or what Brian Walshe did. And that's why I think if the prosecutor had stayed and argued it, the judge would have come out on their side. So I think where it's going to come out is that the defense can say there isn't enough to show homicide. We don't know what happened. Even maybe it could be this, it could be that, but I don't know that we'll have to see whether the prosecutor is willing to agree that he can say it was sudden unexpected death.
Yeah. By the way, as everyone destroys me in the chat, I'm not, the argument I was making is not that he is correct, that Tipton is correct in the argument he's making. I'm just saying he was making a valiant effort in arguing his point, which I think was aggravating everyone, including me. But I think it's, he was advocating strongly for his client.
Yeah, and if you were on trial for something, you'd go, yeah, he was doing his job. I just found it annoying because they didn't put in the evidence. He gave it to the jury in opening. They should never have heard it to begin with. And now he wants to use it, even though there's no evidence from their side or from Brian Walshe that he saw her dead in the bed. He still wants to use it, and that annoys me.
Yeah, and look, I mean, they're going to look at the evidence. I mean, they're going to look at the materials, the devices, the hacksaw, the hatchet, the wire cutters. They're going to look at those Google searches that Brian himself uses the word murder. And I've said this a lot of times. I think that this verdict is going to come back really quickly. But you also have to account for one or two jurors being like Bruce West, saying that he still has reasonable doubt, specifically as it pertains to this premeditation and this first-degree murder charge. I don't think that any of these jurors are gonna doubt or have questions that she was killed. I think they might, if there are any questions, revolve around the fact that it was premeditated, hence first-degree murder. That's the point I think I'm making, if that makes sense. From Annie K, I'll take the professor's silence as move it along, like the judge. By the way, I love when the judge just stared at Tipton again. All men can relate. Joe, could the prosecution object to that during closings? I guess, can they object on the fly to certain things once this is a done deal?
If the defense closing is improper, certainly the prosecutor can object. It is not common for either side to make an objection to the closing of the other. But there's nothing impermissible about it if you think the closing is going beyond inferences from evidence, or it's doing something else that is not permitted under the rules or under the law.
Elizabeth Kim, Joe, is the now very important for the appeal, and or why would this word be so important?
I think she's referring to my comment in the instruction. Now there's only murder one before the jury, or the way it went. I just think it's not it's there's no reason to have it, and it does suggest that maybe there were other charges that are not there, and so I think they could have just pulled out the now, and it would have been just as accurate. But I get to be very picky about language when it comes to things that are legal in nature, and I think you have to be really careful and really look closely. And I think, from what I could tell, because we didn't have the draft in front of us, each side did a pretty good job of doing that.
Yeah. Yvonne Clark here, and this is a great point. If Tipton wanted to use sudden unexpected death, or SUD, he should have at least put up an expert to testify to that as evidence. Why didn't he get an expert up there to say it's plausible?
Yeah, but it wouldn't help from the medical examiner. The problem is not that condition exists. The problem is you need evidence tying it in some way to Brian Walshe and Anna Walshe. And we don't have that because Brian Walshe didn't get on the stand and say, I saw her dead in bed. And it doesn't matter whether the evidence as to the sudden unexpected death came from the medical examiner or the defense put on a medical expert. Neither of them can tie it to Anna Walshe.
Yeah, this is what we're talking about right now, about should they have called any witnesses. But then I go back to Josephine Santamoro here. What about this, Joe? The jury is going to be extremely mad about not knowing about his pleas, I guess, after the fact. Will they be?
I don't know. I mean, a lot of things are kept from a jury because they're not relevant to the charges in the particular case. And for those of you who think he is guilty of premeditated murder, it is the prosecutor that made the argument that the jury should not have known about those pleas.
Here we go. Not to pick on Bruce West, he's just making kind of a contrarian point. And look at him. My family has experienced sudden death events. I'm sorry to hear that, Bruce. So you got that. And then there was another comment. I'm just looking for it.
But I want to respond to that. The issue is not whether somebody could die of sudden death and, look like they had no medical condition before. The issue is whether without Brian Walshe even testifying to it, it's really an issue in this case. And whether it undermines premeditated murder.
Yeah, and then you see Yvette. This is interesting because Yvette and Bruce could be jurors, and she says the sudden death thing is bogus. In my opinion, he had motive. So there's going to be, I think, a Bruce West on this panel of jurors, and he's going to say that in the deliberations room. He's going to say, I had a family member who just up and died.
Right.
And Yvette's going to say, yeah, I'm sorry that happened to you, and I'm sure you did. But did you or your family members after that? Did you go and cut her up and use a hacksaw? And you're right, and that's going to be the follow-up question, and
talk about murder and have a motive to kill her. Yeah,
correct, and all that is going to come together. And I think, look, jurors are smart. Massachusetts jurors are particularly smart, I think. I think they're right here. I was just going to say this. This is weird. Julia Nielsen, another person I don't shout out enough, who's here all the time. The jury will get it right. Here's a poll. Are you surprised by Brian Walshe will not be testifying? No, didn't think you would testify, 50%. Yes, thought Brian Walshe would take the stand, 50%. COE, how come one of them are circled if they're both 50%? That's prejudicial and misleading. I'd like to strike that from the record. That's how I'm going to talk from now on. I'm going to talk like an attorney.
And I would say that absent Tipton in opening saying he's going to testify and here's what he was going to say, I would certainly have been among that would say, no, he's not going to testify. because defendants don't typically testify, and his getting on the stand would have been particularly risky because of all the crazy behaviors that he couldn't have explained.
Mm. And now I'm confused. Is the art fraud going to come in, Joe?
It's coming in under, well, they came in already. They know somewhere in this evidence, they know that he committed art fraud, and it's coming in on whether the jury should be able to use the idea that he committed art fraud as to say he's more likely to commit another crime.
Mm. Do we know the composition of the jury? It is 9 women, 7 men, 4 alternates on there. Think about coming to Vancouver. I don't want to rub it in, Kathy, but Miami just beat Vancouver for the MLS. You know, I never watched a soccer match in my life till my kids started playing soccer a year ago, and I kind of love it. I'm obsessed now. I would, yeah, I love it. And I don't know why. It was just one of those, you know, this, Joe.
Yeah,
like
I'm not a fan. I watch it, but I'm not a fan.
In Jersey, it's not like a thing. Like growing up, like
Well,
no, I mean,
they do it in all the schools. The kids all play.
They do, but it wasn't like a big deal. Like here in Florida, it's a huge deal.
Well, you've got a much larger population from parts of the world where soccer is a big sport, particularly in Miami.
Yeah, people are, you know, absolutely. It's a beautiful sport. That's why they call it a beautiful game. So. Here, I'm just looking for, I agree with Prof. Joe here. Back to Elizabeth Kim. Thank you for these super chats. I do agree with Prof. Joe. Every piece of language is important. Details matters. Even in my profession, I'm a bit of a whatever about it. But what's your profession, Elizabeth Kim? I'm curious. Don't tell me you're like a magazine editor, because then of course it would matter. But I'm curious. Now that you brought it up, I'm surprised, but I thought it was a terrible idea. If he did take the stand, it would have been an absolutely horrible idea, I think, for him. But it would have been interesting for us, selfishly, of course. And Joe started it off saying me, and that's how I feel. I wanted to hear him testify. I'm just. What do you think, Joe? If you had to guess, and we'll wrap in a minute or two, do you think it was his decision, or do you think that Tipton? Do you think he went to Tipton and said, "I don't want to testify," or do you think Tipton went to him and said it's not a good idea, and he's like, "You know what? It's probably not a good idea."
I think Tipton probably initiated the conversation about it. I'm sure they did it before, and now that the evidence is in, I think probably the defense lawyers went back to him and said, you know, we said this to you before. Now you've heard the evidence. Let's run through the kinds of questions you're going to get. We do not advise you to take the stand. And it was good advice. It's just that opening shouldn't have occurred the way it did.
Yeah. Quick program reminder. I think we're going to come back tonight. It's a weird time of year with the holidays coming right up, and we are kind of short notice. Headed to Tim Jansen's daughter's wedding. By the way, someone floated the idea, and I sent it to the COE. There is a registry if anyone is interested in. You know, Tim's such a great guy, and he's been here for us all along. So this, you can email the COE, survivingthesurvivor@gmail.com. If there's a registry out there, if anyone's interested in getting Tim's daughter a wedding gift for whatever reason, you're free to do so, and the COE can direct you that way. But because of the wedding, the COE and I are going to be out of pocket literally at that time, starting at like 8:30 in the morning, pretty much into the afternoon. If they're still deliberating, I'll try to hop on a laptop, but Joe has graciously offered to be here at 8:45 a.m. and kind of run the show. And obviously you are in great hands with Joe, and she's got her own channel that will be simulcasting it on. Prof. Joe Explains. Are you going to do a wrap today, Joe, at 5?
Yes.
Okay, so Joe is going to do a wrap up today at 5. I think we're going to come back at 7 and follow up Donna Adelson and the fact that she is now in Homestead. Steve Cohen has lined up 3 other former inmates to kind of dig a little deeper into that, because it sounds like she is in for a world of hurt there, literally and figuratively. one of the former inmates said she is going to be greeted, even at 75 years old, with a beating at Homestead. And, you know, I don't wish that on anyone. All I can say is good luck to
A
her.
beating, beating?
Yeah, like a physical beating, because they don't think she's going to be able to control herself. And the former inmate said that she will be put in her place in a physical manner within the first few weeks. So I always think, how would Carm handle that? I would have to have Carm would, I don't know, I might have to get her boxing lessons. Literally about 30 feet from where I'm sitting, there is a guy, he's Israeli. He's a former Muay Thai champion of Israel, and he teaches self-defense. And so every once in a while I hear the bag, like the heavy bag, and the punching and the kicking. He was also a special ops guy in the Israeli army. And so now I think I might have to get Carm here to train with him in case Carm ever ends up
In
in
case she
prison.
decides to commit murder and get convicted of it? I
Yeah,
don't
then
think that's a big worry.
no. Joe, do you want any chance you want to practice Muay Thai with Carm?
I wouldn't mind learning, but not because I think I'm going to go commit murder.
Yeah, I just want Carm to be able to protect herself if she ever ends up in trouble. I thought that was a vape pen right there, Joe Patuto. I was about to lose my mind that you were vaping, but that's just a pen in your
Oh,
mouth.
no, I would never vape.
Yeah, vaping, no good, no bueno. I do think I'm going to start speaking to my kids like a judge, telling them I'm going to strike stuff from the record. I'm going to ask them for evidence of all of their explanations. I'm going to start doing that tonight. I also have to get the Home Depot.
Too? Exiting cars.
Yeah, my normal, because they're growing up in this world. Look at this. LOL, Joe just shut that down so fast from Space Coast. I do think okay, hold on a second. This is important. FYI, Joel's statement about Tim. Please don't email me, as I'm still catching up on so many other emails. I'll leave a YouTube post for subs and members with info. Okay, so it'll be posted on YouTube. Obviously, zero obligation, but some people were asking. Tim is a stand-up gentleman, and his daughters are great, and his wife's great. And if you want to, it'll be there. And if you don't want to, there's no pressure at all. People have also been asking about Drina. She was supposed to appear on the show last night. Was it last night? I can't remember. Whatever night it was, it wasn't last night. She had a really bad cold, according to her mother. She's also going through 2 nights ago. She's also going through a really difficult time. She's open about her drug addiction, and I think there's, potentially withdrawal and just readjusting to life on the outside. So it's been really tough on her, but she knows you guys are thinking about her, and the COE and Steve Cohen have been in touch with her. And Joe Patuto, as always, I will let you have the last word here. At the end of the day tomorrow, if they go and deliberate, does it come back? Do they come back with a guilty verdict? Your final thoughts here.
I still think they will. And I think at the very worst, they may end up with a hung jury. But I still think that when they instruction and they actually take a look at the evidence, that they will convict. But I will add, in part, it's going to depend on how well the prosecutor ties everything up and points to the evidence on which this jury can say, yeah, it was premeditated.
That is the final word from Professor/Judge Joe Patuto.
Well, not the final word. Hopefully, I hope that I continue to talk.
What's going on with your cap and gown? Is there now something on top of the cap there?
Yeah, there's a Christmas baseball cap on there.
Oh, I love it. I love stature. Everyone, Joe will be here at 8:45 a.m. for closings tomorrow, 45 minutes for each side, then deliberations. And tonight, 5 o'clock, Prof. Joe Explains. 7 o'clock, we will likely be here. Please check show times out for us on Instagram at Surviving the Survivor, Instagram at Surviving the Survivor, on X, the cesspool. It is at Pod. One hacked into my Facebook page for Surviving the Survivor. I can't figure out how to get in right now. I'll have to show the COE. and she's also the head of our IT department. On that note, love you, America. Huge thanks to Joe Patuto. Carm is shadow boxing as we speak. I'm getting my Tyvek suit and booties to go into Home Depot with a snorkel to see what the reaction is.
And
We'll let you
goggles.
know. I'm going to do that next week, and we'll let you know what happens. I'm sure the COE is going to be eager to film that. We'll be very excited to know I'm doing that. All right, everybody. Have a great night. We'll see you 5 for Joe, 7 for me, and tomorrow 8:45 for closings.